Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello, and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican praise service Latin.
That's literally not true.
I didn't ask you to interrupt me. From C.
Is that correct?
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Happy afternoon on a Tuesday morning to you. I'm sitting up straight, good posture, trying to fix my back. Went to the doctor this morning, got all bad news. But the good news is that I'm alive and I still get to do what I love to do. So that's wonderful. All right, welcome. As we get started here, let me turn the music down just a teensy bit. For those that I did a members only live because I had to do 10 of them, and now I'm done. I filled in the form. YouTube's supposed to be sending me a YouTube backpack, which is cool. But most importantly, I've met the terms, so now that my people want to work with me more. So that's what I wanted. Yes, Thurston ditched us. I don't know if they took a plea deal. I don't know what happened, but it just wasn't happening today. So we'll have to figure out what we're going to do next. But I have some updates. First of all, I went to the post office. And what are those red spots on your back? Just blood. It's fine. Don't pay no attention to the bleeding. I did not get poked with needles today. That apparently is Thursday, right before the podcast. Here's what happened. I want to see how far. Let me tell you. I ran to the post office, and I ran in, and the postmaster was there, John, at the counter.
Hello.
Not one of the clerks, but John was there, and he sees me coming. He sees me pull up, and he knows what box I am, and he runs and he gets my stuff. I come in there, and he's got like a pile of stuff. A bag with a couple things in it, and a couple boxes, another letter envelope here. And he's just like, he's scanning them all. He's like, hey, here, we've got all these. And he brings out one box, and he's like, this box arrived, the one that came from Walmart, arrived to us a little damp. I'm like, oh, I sheepishly say it probably is pickles. Yeah, he's like, yeah, and it smells like pickles. Walmart delivery, as they tend to do, one more jar of pickles broke. So 2 came unbroken, but 1 broke. And he's like, it's been here a couple of weeks. Okay. I'm like, a couple of weeks? I've been here and got the mail. You guys didn't give it to me. So you could have given it to me previously. I mean, a couple of weeks. I went and got here around my birthday, the 24th, and
the Walmart.
It wasn't there then. So he's like, yeah, it's been here a couple of weeks. And I'm like, I'm sorry. And he says, so I have to ask, why are people sending you pickles? I said, it's a bit of a long story, but basically it started with the day that we were taking a break for lunch, and I described what I was going to eat for lunch, what I was going to make, or what I had just had for lunch. And it was a sandwich you had made. And I said, of course, you can't forget the pickles because they're my favorite. And it just stuck from right there. And then later on, when we were trying to steer the channel a little bit as far as let's stay away from the political stuff, because we can always find stuff we want to fight about, right? And politics is great about that. We don't want to fight. We like to come together and have some fun. Then it sort of naturally, pickles not politics. And Steve, when he drew our little logo, our artwork, of course, you've got a pickle on there, and pickles have just stuck. Pickles are not my world famous all the time favorite food. Right? As a matter of fact, some of the stuff that people have sent me to taste has been downright nasty, and I'll say that. Not everything dill flavored was a good idea, but some of it has been delicious. Anyway, the spicy maple bourbon pickles, they arrived. 2 of the 3 jars arrived unbroken. I think that's a win. Honestly. So thank you very much for that. But I also got a bunch of other packages, including the missing one, They had the inflatable pickles. Those arrived. Thank you. We got a beautiful envelope with a birthday card for myself, a letter from my family, as well as some artwork for my daughter. This is watercolor and pen. She has it right now. I can't show you, but she loves it. It's a little picture of a girl, looking at a robin, and it's beautiful. It's a watercolor and ink, which is amazing. My birthday card was also hand painted. All of them, just amazing, wonderful. Thank you, all of you. I was supposed to bring in the notes so I could tell everyone's names. I think I got everything. And thank you. I got a ton of dill-flavored stuff. Everything from spicy sunflower seeds. I got habanero-flavored almonds. Just a big thing of spicy Cars candy, like trail mix stuff. Let's see, puff. Spicy dill pickle puff, Vlasic puff balls. Oh my, there's so much. There's so much. There's just a ton. Sesame or sunflower seeds that are dill flavored. Then I got another large package, a large flat package, and I could tell immediately it was for me. It was up on the back wall of the post office, like leaned it up against the wall so everyone could see it. And it's from Bug Dugger, and it's just coming, to a Recovery Addict. And and he's like, "Oh, don't let me forget. I mean, I've got this one for you too." And he brings it, and you scan it and take it home. I opened it up, and it made me cry just a little bit. And it has a note in there that I'm going to leave. It was a gift for my granddaughter, and for her parents, my son and daughter-in-law. But the note inside. First of all, I was supposed to put this on the screen. Hang on one second. I can just hold it up. It's not going to do it justice, though. Let's go full screen real quick. They sent this enormous, absolutely enormous diamond painting artwork of a little elephant and flowers, a little whimsical thing. Just to get scale on this, it's 24.5 inches wide by 17 inches tall, and that's just the part that's painted, the diamond painting part. It's massive. I haven't finished counting, but that's somewhere between 38,000 and 42,000 individual hand applied little beads on there to make that possible. But this is not all. This came to be because of three viewers, who each did part of this and then shipped it around the country to each other's houses so they could all complete a portion of this and then send it on. Dear RA, all of this was possible due to your YouTube channel. 3 people who landed in your chat over the years have become good friends. We found out we had so much in common. We went from chat to messenger to talking on the phone. We'll be lifelong friends, all due to you. We're able to vent to each other about things that are going on in our lives. You have given us such a wonderful gift. We had so much fun working on this gift together. The fact that I'm going to become a Grammy for the first time in a few short weeks made working on Ellie, the name of the painting, Ellie, even more special. None of this would have happened if not for you. Congrats, my friend. It's signed by Bug, Melissa, and Nosy Rosie. Absolutely, that was one of the most touching things I think I've ever received. That is just awesome. It's so cool. And I will be. We're going to be packaging the back up. I've already sent a picture to my daughter-in-law. I called her. I think I woke her up. She was sleeping, and said, "Hey, this is just absolutely amazing. It's coming your way." It is so cool. Thank you, guys. Allergies are really bad this year, but we've sent that on there. Generosity beyond belief, and just the amount of work that went into that, and also just the idea that something really cool has come out of us watching court together is amazing. And thank you very much for sharing that. Thanks for contributing and making all that possible. That is a ton of work. I know, because my daughter's worked on diamond painting. She's still working on her first diamond painting picture. It is a ton of work, and you can spend hours and hours plugging away at this, and it looks very similar to how it was you started a couple hours before. So thank you very much. I'm so excited. It's going to be they're going to hang it in the nursery for my granddaughter. They're super excited for it as well, and we'll send that on to them here. We'll get that mailed out. But thank you, and Bug, thanks for your generosity and making all that possible and more. So thank you. So there's that. That's why we were late. I gathered the family around and we talked about that, and we read the letter together, and all just had a little sniffle together, which is really cool. And then we did a call with my daughter-in-law. So, all right. With that said, now we're going to go watch people get sentenced for court. We can go up to Thurston County, Washington, where we're doing just regular court stuff, which I'm fine with, which is great. As we wait for our next court to appear, and I obviously have a couple phone calls to make to order to get put on the media pool for a couple trials.
Sure. Yeah, we'll be on recess for a few moments. We'll have Ms. Claremont send over that motion as well. So we got a few things in the works anyway. So we'll be on recess for a few moments, and then we'll come back with, I think that's Ms. Claremont's matter.
How can they turn us off the second? They've been on all afternoon. Let's see. You sent something to watch. Judge Ricky, Josh, is that what you're talking about? Give me just 1 second. We'll jump there instead. Thurston had been going like all morning until then. Let's see. This is going to be Judge David Ricky. Okay. Time-wise, it's 27:54. Let me find it here. I think it's that one right there. Okay, here we go.
It's entitled Ryan C. Cheetum versus the Kansas Department of Corrections, case number 2025 CV 294. Elizabeth Fowler appears representing the Department of Corrections. Joshua Andrews appears representing the petitioning inmate in this case. Ryan C. Cheetum versus the Kansas Department of Corrections, case number 2025 CV 294. Elizabeth Fowler.
You got to mute your YouTube, Judge.
All right. Again, Ryan Cheetum appears as the petitioning inmate, separately from his lawyer by Zoom. This matter comes before the court at this time for further proceedings. There was an earlier proceeding in the case where the court recessed to allow the attorneys to research an issue that arose regarding a possible liberty interest suffered by the inmate in this case for alleged loss of accrued good time credit. The court has looked at the file, and it doesn't appear that there was any documents that verified that he lost accrued good time credit. But I'll ask Ms. Fowler, did your research or further checking indicate that he did suffer that penalty?
Your Honor, as I filed with the court and made available to my opposing counsel, I filed what was marked as Exhibit H, which is good time award record for Mr. Cheetum for the time period in question. There were 4 DRs that Mr. Cheetum received convictions for during that relevant time period, including the DR which he appeals, the battery DR. The document reflects that he had good time withheld, so he did not earn any good time for that period in question, but that no good time was forfeited. And I did provide that to opposing counsel shortly after our last hearing.
Your Honor, may I address the court real quick before we proceed?
Just a moment. Because okay, go ahead. Go ahead.
I'm choosing because I was on mute, but I'm choosing to invoke my right to represent myself because, like I said, I'm not a lawyer, but I, you know what I'm saying, comprehend the law. I feel like a little bit good, and the liberty interest that I feel like is at hand it refers to the Wolf versus McDonald, and it's about the the due process procedures in a disciplinary hearing, the impartialness of the hearing. Also, you know what I'm saying, I would like to address the good time credit too that she's talking about, because the document it's extrinsic. It's an extrinsic piece of evidence, and I feel like I got another form that shows 133 days available versus 0 days, and then the document that they provided to the court states 23 days. You know what I mean? So I've read a case law that says that we can't challenge the fact that with unearned good time is not a liberty interest. Good time that's withheld is not a liberty interest because one hasn't earned it yet. Well, I feel like the document, you know what I'm saying? I feel like we need to have an evidentiary hearing or be able to prove like or direct the courts to direct KDOC to show the good time that I did have in the bank that was available, and whether or not it was subtracted, the 23 days was subtracted from that, because I feel like that document that was provided only shows the 23 days that were available, and it's saying that, you know what I'm saying? I feel like it's ambiguous and it's vague, sir, you know? And I also want to address the fact that there was insufficient evidence to convict.
Okay, Mr. Cheetum, I'm just going to put a hold on things for a moment.
Go ahead.
I was going to address your attorney regarding the liberty interest regarding accrued good time credit. Mr. Andrews, did you have any additional remarks to add to Ms. Fowler's?
Your Honor, in light of my client, he had let me know before court that he was desiring to represent himself going forward. So I was going to ask the court to, I think he has the right to represent himself on these proceedings. I was going to ask the court to allow him to represent himself going forward and propose that I remain on the hearing as standby counsel, but that regarding any substantive comments on the issue that Mr. Cheetum's requesting to represent himself on that.
All right. Given that statement, Mr. Cheetum, are you indeed wanting no assistance from legal counsel in this case, and instead you want to represent yourself in this disciplinary hearing matter?
I mean, it's like I feel like my argument, you know what I'm saying, with the liberty interest is being swayed.
That's a yes or a no, really?
Yeah. I'm wishing to invoke my right to represent myself. Yes, sir.
All right. Stay on the meeting, muted, Mr. Andrews, as standby counsel. All right. Mr. Cheetum, you're trying to cover a lot of ground really, really quickly. I'm going to go back to Ms. Fowler for a moment. He seems to suggest that somehow the records don't reflect that he didn't lose accrued good time credit. Do you know what he had earned as of the date of the offense in this case?
Your Honor, I don't have an accounting of all of his hours, but before we even get to that, Your Honor, I would say first of all, his petition in this instance didn't mention good time at all. This is an issue that came up later after he reviewed my brief in which I said he had no liberty or property interest. And then he's since then inserted this good time argument. I don't think that's proper, but I did accommodate, provided the record. Now he's asking for additional records. But Your Honor, the burden is his. It's not mine to prove that we didn't take any of his good time. He didn't assert it in his petition. I've produced what we have related to the good time record for that time period. He hasn't asserted any property or liberty interest that would invoke his right to those due process protections, as he's indicated that he was denied during this hearing.
I did state that I wasn't able to call witnesses, and I also stated that I was never afforded the appeal or whatever, as far as on remand of the record, the clarification of the record. So I did state liberty interest, and I'm looking at Wolf versus McDonald's, and it says that I have a right to prepare a defense. I have a right to call witnesses on my behalf, and I wasn't afforded that opportunity to do that.
Started law school 2 weeks ago.
And Your Honor, the case law is that he has to prove that he had a liberty or property interest.
Right.
And
so the liberty.
Okay. Cheetum, hang on just a second.
Go ahead. Yes, sir.
I do want to refer to the Secretary of Corrections ruling in this case as part of the exhaustion of administrative remedies. The sanctions that are referred to on the back of that document indicates 15 days disciplinary segregation. And that's
right. So the issue was, remember, I said that I lost good time that the unit team took. The disciplinary hearing officer didn't take good time, but the unit teams did. So that's why we recessed, so that we would be able to provide to the courts the documentation on where I lost good time at. So the good time, the exhibit that Ms. Fowler submitted to the courts, I'm saying that it's vague and ambiguous, sir, because it doesn't show. It doesn't show what I lost in the bank. It doesn't show. It only shows a summary of something. And in my opinion, in my position, it's extrinsic. We shouldn't rely on that. We should.
Well, then what would you rely on?
I would rely on no, absolutely not, sir. I would rely on either an evidentiary hearing so that the unit teams can testify to exactly what was lost of good time. But to rely on a paper that I have that's contrary to her document, one says 23 days. My document says 133 days. So which one do we go with? Which one, you know what I'm saying, is proper?
Did you even raise this claim in your petition?
I mean,
corpus relief?
But you chose to entertain it, though. We recessed to entertain it, and now I want to further entertain it, but I also want to address the fact that I wasn't given a fair partial hearing.
Okay.
I mean, I just want to make sure that that all the rights are afforded to me, because, like I said, according to Wolf, it's saying that that we're entitled to an impartial hearing, and my hearing wasn't impartial because I didn't swear in and raise my. So not only was I able not to provide a defense, which it says I'm allowed to, and if staff assistance was appointed, I was supposed to be able to direct and guide that staff assistance, which I didn't. And then the sufficiency of the evidence, you know what I'm saying, how they convicted me, it was a short statement. An adequate statement of reason must be based, point out the essential facts upon interference were based. You know what I'm saying? And it was the record, due to the preponderance of evidence, it was found guilty. But Secretary of Corrections remanded it for clarification of the record because they wanted to know specifically by the reporting officer whether or not I made physical contact in an assaulting manner. And this decision to uphold wasn't until 9 months later. And I wasn't a part of that second process, which I also have a right to be present at every stage of the disciplinary hearing. So, you know what I'm saying? So for us to just focus on the good time, I feel like is an attempt to sway an argument that we already know is going to get denied anyway. So that's why I chose to represent myself, because like I said, I don't want to get taken advantage of because I don't have the degree as Mr. Andrews. So if I'm wrong about what I'm saying, you can let me know, and I guess my remedy would be to appeal.
Well, he got that part right. Can always try to appeal.
All right. Mr. Cheetum, I don't have any record in this entire file that indicates that you lost already earned good time credit.
Right.
The Department of Corrections record should reflect if that was part of this disciplinary proceeding or not. And clearly, it indicates that the sanction that was imposed is 15 days of disciplinary segregation only. So I think Ms. Fowler's point is well taken. There was no loss of a property interest or a liberty interest under those circumstances. You cannot do is interrupt me when I'm talking.
Right, but you knew that our last court day, sir. So why would you recess it for us to be able to provide further documentation? And when her documentation provided to the court is vague, now you want to go back to the DR initial that I received 15 days disseg to substantiate in denying my petition. So basically, you're not going to afford me an opportunity to combat her document, is what you're saying. So why did we recess it in the first place?
To have her look into it further, which he has done.
And I got a document that contradicts her document, and I'm trying to provide that to the courts. So how are we going to go about that? Her document doesn't show 133 days.
And it shows as part of your disciplinary proceeding that you incurred a loss of accrued good time credit. Is that what your document shows?
Yes, sir. It shows that there was more good time available other than 23 days. So what I'm saying is, The documents that we
Mr.
should
Cheetum,
either have.
let me ask you this.
Go
Let me
ahead,
ask you.
sorry.
You've
Go
had
ahead.
multiple disciplinary proceedings, haven't you? Are you sure that if there was an adjustment of your good time credit, it wasn't connected with one of these other disciplinary cases?
No, I'm saying exactly that. I'm saying I want to have an evidentiary, sir, so that we can have the unit team managers come and provide either testimony or further documents. Because I can send this over to the courts. I don't know if you can see this right now, but the document that you're looking at, it shows. Hold on.
Auto blurs.
Okay, I really can't see it. It's just all blurry.
Okay, you see where it says
good time award.
Hold on, why it's being blurred out? Why is it? You see that word? Yes. Are you blurring it out or what? Well, it says 100. Okay, so
document he's holding up.
It's the same one, sir, that she has, and it shows 23 days versus mine says 133 days. So my argument would be that this is an extrinsic document, and we have to further investigate the actual good time that was taken from me, because this paper shows the 23 days outside the Senate bill. It shows more than 23 days. You see what I'm saying? Like the document.
I really don't.
The document that's in front of you, sir, it shows available good time credits for award period. It says 23 days. My document says 133 days. And then it says good time credits awarded. It says 133 days. So what I'm trying to say is this paper that we're relying on to see what was available and what was not, what was forfeited and what was not, and what was withheld and what was not, to establish a liberty interest is vague and ambiguous. And I'm asking the court to allow an evidentiary hearing so that the unit teams may present further evidence. And I feel like I deserve that. Because
to allow that, Mr. Cheetum, I would have to be convinced that the records from the Department of Corrections are incorrect, that you actually sustained the loss of accrued good time credits as a part of this disciplinary conviction. This is not a proceeding to determine what good time credits you're entitled to as a prison inmate.
Right, I'm not saying that, sir. I agree exactly what you're saying. I know what you're trying to say, and I just want the opportunity to show that I lost good time. I lost 23 days of good time. And I wanted
23 days withheld, Your Honor. He had them withheld. They weren't forfeited. He didn't earn them.
So let me just say this real quick. The unit teams can only take good time you've already earned. They can't take good time that's not in the bank. The disciplinary action can take up more than 6 months, but the unit team is only allowed to take what you have already in the bank, Your Honor. So that's what I want to be able to cross-examine and to have the unit teams testify to. So let's just say this: if you pay me for working for you, sir, and I got money in the bank from working for you, right? So the unit team is able to take from that money that exists in the bank. They're not able to take away from next month's paycheck. You know what I mean? So that's what I want to establish, that I lost good time that I had in the bank, not future good time.
Ms. Fowler?
All right. I don't have the document before me that Ms. Fowler has. I don't at the moment. When was your additional exhibit submitted to the court?
It was filed into the record yesterday, Exhibits H and I.
All right.
And if I should do that differently next time, Your Honor, I wasn't sure how best to provide those documents. And like I said, I did provide those to opposing counsel, and I did provide our good time record shortly after our last hearing. And I didn't receive any additional documentation from Mr. Cheetum.
All right. I notified those exhibits are pertinent to our discussion. So I'm going to recess briefly and access those two exhibits.
Sir, this exhibit I found yesterday, and I tried when Mr. Andrews.
The court will recess briefly.
Yeah.
Yeah. He thinks he's winning.
I done beat 3 trials last 7 years doing what I'm doing. Hey, Crawford.
He seems pretty pleased with himself. Sloth Life, thank you very much. I appreciate that. why didn't he keep his attorney and request his attorney file this paperwork? Instead, he's sitting there holding the evidence that the judge doesn't have in front of him. The judge can't make a decision on something that's not in front of him. He seems quite pleased with himself. He's explaining to the guards, who, let me just frankly say, don't care. I'm not saying that guards don't care about the job, but they don't care about his little legal battle here. This is not their fight. He's explaining to them because the judge wouldn't listen right now. I don't think the judge is going to side with him. First of all, firing your attorney and then interrupting the judge to say that you don't believe the documents that the government has on you are right. I'm not sure that's the best way to go about this argument. They're not in prison because they're smart, says Little Stubby. That's not why? No. Yeah, he's actually in prison because he shot and killed somebody over an argument over, I guess, somebody being uncomfortable with him carrying a gun. Well, I guess that proved true. So he's in there for a fatal shooting. We're going to tell his cellie that he won. Oh yeah, he's already bragging. He's already bragging. I think he's thinking he's got some mileage out of this. I don't know what his sentence is now, but I can't imagine it's less than 10 years. And he's worried about 23 days. Look at this. Maybe he has. Maybe he's won this fight and he'll get 23 days of good time credit re-awarded back onto his sentence, applied to his sentence. Yeah, 23 days is just a little blip on the screen for him, I think. It's 110 days. Now that's more significant. That's a third of a year, right? He's jacked. He's on cloud nine. First day as a lawyer, already winning. Made the judge go into a break. It's not what you think it is. Sticking it to the man is worth so much more. Oh, right. Just being able to claim the win. He's going to be writing briefs for people in jail for months after this one, as the legend gets passed around the cell block. So 133 versus 23 difference. Okay, so I wasn't paying that close of attention, but he seems to have at least researched the rules. Here's the judge. Let's see what happens.
The time the court will resume the record in the Cheetum versus KDOC matter. All persons appearing as before. The court has now had an opportunity to review the very recently filed documents, Exhibit H and Exhibit I.
Which Crawford doesn't have.
All right. Mr. Cheetum, you're muted.
There you go. All right. Can you hear me?
Yes. I have before me a good time award record from Larded State Correctional Facility. The award date is stated at 12/11/2024 up in the corner. Is that the document you have?
No, sir. The document I have says the same similar good time award credit. And then it says from a period of 2024 through 2022. And it says 133 instead of 24.
Okay, this is dealing only with the award period from August 18, 2024 to December 18 of 2024, which was apparently while this disciplinary matter was pending.
Right.
Yours is apparently for the period before that.
Okay, so, right, I get that part, right? But it's saying that, I guess according to the Senate bill, it says that because of my crime, I'm only allowed either 21 days or 23 days per period. But it's like that only shows, it doesn't show what was taken out of that bank, that what my argument is, sir. I'm saying, from my understanding, I just asked my unit team this question. I said, is it not my, because if I'm wrong, sir, I'm wrong. I'll kick rocks, you know what I'm saying? But what I'm saying is the good time that I've already earned that was in the bank, I'm trying to figure out how can we show that it was deducted from that? Because that paper just shows the 23 days and you know what I'm saying, what was withheld and this and that. My other argument, you know what I mean, I don't know if you're going to entertain it or not, because this is why I chose to represent myself, because me and Mr. Andrews was kind of at odds with it. It's like, I feel like the Supreme Court, you know, and I'm not asking you to overthrow them, and I know you're not going to. So my thing is, our Casper website pages show an early projected release date, and it shows a later projected release date. So, like, according to Casper, we already earned the good time. We already got it. We just have to demonstrate good behavior. And if we don't, it chips away and it goes to the later. It doesn't go from the later to earning the good time to the earliest possible. So I feel like, okay, from a business aspect, if the bank account has money in there, and you know what I'm saying, on paper it says, hey, Mr. Cheetum's already got this money in the bank because he's already earned his good time. All he has to do is show up to work. And if he works, then the books are cleared. You know what I'm saying? So it's like, I'm not trying to overthrow the Supreme Court, but that's why I didn't want to focus on that. And I'm like, well, hey, how do we not know from what the unit team managers is telling me? They're saying I can only take away what you earned. I can't take away what you didn't earn. You know what I'm saying? So that's why I'm like, why should we only rely on the good time paper when we can have these unit team officers come and testify as to their duties and how they go about deducting good time?
So I should rely on your hearsay statements regarding stuff that you say have been told to you by unit team members rather than the actual documents that the Department of Corrections maintains?
No, sir, I'm not asking you to rely. Okay. I'm not asking you to rely on
I think I'm prepared to rule. Mr. Cheetum, the documentation that's been provided by Ms. Fowler at the suggestion of the court indicates that you did have good time credits withheld during this pending disciplinary matter of 23 days. It clearly shows that you were not awarded those 23 days that you might have earned, but for the disciplinary conviction. But it doesn't show in any way, nor is there anything in this entire thick file that would indicate that as part of your disciplinary sanctions, you received a loss of accrued good time credits. In fact, the Department of Corrections has demonstrated to the court documents which indicate the concern the court had the last time we were in court. I think that you lost non-earned credits.
All right, I will not dispute that. So is that the only liberty interest that I can argue, or is that what about the?
That's the only one that has been suggested to the court.
Okay, exactly.
In fact, I'm not even sure you raised that issue in your petition.
Right. So now we're getting somewhere. So now this is why I said for us to argue that, and I didn't argue it. It was only meant to deny my petition. That's why I was opposed to arguing in the first place. What I did argue in my petition and cited was the fact that I wasn't afforded to call witnesses, sir.
But you only reached those hearing defects, according to you, if you can show that there was a legitimate property or liberty interest triggered.
So the liberty interest.
You did not get fined. You did not lose any financial matters at all. So there was no property interest triggered here. And the liberty interest would have been theoretically from the loss of accrued good time credits, which I think the Department of Corrections has shown didn't happen here. In fact, numerous documents would seem to indicate otherwise. So the court's going to find that we're not going to reach the issues of due process as there was no legitimate property or liberty interest triggered by the disciplinary sanctions imposed in this case. I'll also just note for the record that there appears to have been some evidence to support the hearing officer's decision. And that's a relatively low standard, and it was certainly met in the view of the court upon review.
Can we elaborate on that, or we just
no?
Right, exactly.
That's an observation that the court has made.
Yeah, what observation? Just like you said that you observed her document and you recessed it to get it. Come on, man. All right. So
Mr. Cheetum, I'm going to find in this case that the disciplinary sanctions in this case did not involve a protected liberty or property interest in this case.
No, and I want to
put this on. The claim for habeas corpus
is denied.
Should not be furthered.
Right, and I just want to put this on record for appealing purposes. I did not argue the fact that good time credit was forfeited. This was erroneously projected to the court and presented to the court only to deny my petition, as stated by Judge and Ms. Fowler, that it was not even cited in my petition. So,
right.
So why
you didn't raise the issue of a protected liberty interest even in your petition, Mr. Cheetum? You argue it now, so that the court.
I didn't argue that. That's what Mr. Andrews wanted to argue.
All right.
Y'all have a good day, man. God bless, man.
Okay. The writ is dissolved, and the habeas corpus petition in this case will not be furthered, and the case is terminated at this time. At this time, the court is in recess, and the court will end the meeting for all.
Wow. He seemed rather pleased with himself, knowing the outcome from the beginning. That he was losing, and he did, in fact, lose. All right. Let's see. Lacey's still active.
Hearing and prepare for that hearing. So Pacific Point Defense is the law firm that does public defense work for the city of Lacey. So I'll appoint them to your case. All right. And then we're going to set a revocation hearing. Well, actually, I guess doesn't look like we have a good mailing address for you. Do you have a good mailing address?
I really don't.
No? Okay. So we'll set a hearing today. Do you have a good phone number that receives text reminders or text messages?
Yeah, I do.
All right. What's that phone number?
867-5309. But it goes 867-5309.
All right. April 30th. All right. So I'm going to tell you your next court date now as well, but you'll also receive a text reminder. That's going to be Thursday, April 30th at 11 o'clock in the morning.
Okay.
All right. And in the meantime, reach out to Pacific Point Defense.
Okay.
We can, and they'll connect you with your assigned attorney for that hearing.
Okay. Thank you.
Okay. Thank you, Mr. McComb.
I'm going to put our contact information in the chat.
Oh, thanks, Ms. Kamari. Are you, Mr. McComb, I see you're on a phone there. Are you able to see the chat function?
Yeah.
Okay. So Ms. Kamari, she's an attorney there with Pacific Point Defense. She's going to put their phone number in the chat so you can have their number to reach out. All right.
Okay. Thank you.
All right. Thank you. Thanks, Ms. Kamari, for doing that.
You're welcome.
And we'll see you back on April 30th.
Okay.
Great. And do we have the Spanish interpreter? No, we don't. Do you know if she's in any of the other courtrooms? I know the interpreter calendar is happening right now. Okay.
Your Honor, is Ms. Grisco in the courtroom?
No.
Okay.
Mariana's over in 2.
No.
Oh, okay.
And then I think.
All right. Just got any others here? Ms. Claremont, are there any 3-4s that you're able to speak to in the meantime? Otherwise, we'll take a brief recess.
Not at the moment, Your Honor. Thank you.
Okay. All right. So we're still, it appears we're waiting for attorneys to be ready. Ms. Kamari, do you have any other 3-4s you're able to speak to?
No, Your Honor.
In that case, we'll take a brief recess for matters requiring the Spanish interpreter. And we'll be on break for a few moments.
Yay, recess. We all love good recess. All right, as they go to break, let's see if we have anything else we can cover today. Let's see, Judge Simpson. Let me just check and see real quick. He's been live. He's on lunch as well, but it looks like they're about to come back. Looks like they're about ready. All the lawyers are face down in their phones, reviewing emails, scrolling TikTok. One of them swiping left a lot. Looks like they're on Tinder. Everybody, one guy head down sleeping in the courtroom. Don't want to be late for court, but at the same time, it's not the best place to sleep. All right. Judge Boyd has a trial starting this afternoon. She's had a couple wild ones. I'm not sure. We might take a quick peek and see what it is. Do you know what it is off the top of your head, Beachwalker, as far as the what's the charge? Looks like my order is ready to ship from Sweetwater. Yay. Placed the order yesterday, and then they sent me an email saying, unfortunately, there's a problem with your order. Financially, the card didn't go through. Like, it's the card we have on file that we used on all your other orders, but it didn't go through. Call my bank, and my bank, in their infinite wisdom, has placed a daily limit on how much that card can spend. And for the first time, I was over it. So I got them to raise the limit one time only, and then it went through. So wait for it to ship today instead of yesterday. It'll still be here probably this week. He's been out for about 35 minutes now and has left the video looking like this the whole time. Okay, so this is probably a lunch break then. A rare peek at what Simpson's Court looks like during lunch when he leaves the live stream up. So we will go and see maybe Judge Boyd, see how she's doing. Wait. We might have... Here's Thurston County. What's happening here, Judge?
All right, Ms. Birmingham. Based on your plea of guilty in this matter, I am going to sentence you to 364 days of jail, suspend 362 of those. You'll have 2 that you have to serve. We'll give you an opportunity to convert those to 30 days of electronic monitoring.
30 days of monitoring or 2 days in jail? What? That was weird. Lindsay LeBerg. Best place to be on YouTube. Thank you very much. 35 months. OG. Stop using the card number, 8675309. I've never had a bill when I use that number. It's great. Math is Is the phone number specific enough for you? Yes. Did you say something else other than Hannah Payne? Was there a new filing in Hannah Payne?
In terms of fees, we're going to charge a $120 probation fee, a $43 conviction fee, $250 BAC fee. I'm only going to impose a $100 fine in this case. I think that total is $513 total to be imposed at this point. And that's based upon your financial situation as presented in the document that's been presented to me by Mr. Keehan.
Thank you, Your Honor.
Sentence will be effective for 2 years. You'll be on monitored probation during that time period. Since you have apparently completed all of the affirmative actions that you have to take, the evaluation to do and the treatment and so forth. You just got to get proof to us that that's so in a form that we can monitor appropriately with the court. So if South Behavioral Health or Behavioral Health Hospital can't provide that to you, you'll have to follow up with another evaluation. Based on what you've done and the records that you could show to them, that should be a relatively easy process. We'll give you some time to get all that taken care of in light of everything else that you've got going on here. So we'll give you until June 3rd to provide written proof of that to the court, of the evaluation. Not to commit any new criminal law violations.
Ohio trial is done.
Interlock device, according to Department of Licensing regulations. Okay.
Correct, Your Honor.
You have to drive without license and insurance as well. You're not to frequent any bars or taverns. You're not to consume any alcohol, marijuana, or non-prescribed drugs. You're not to refuse a UA test or a BAC test if one is requested of you. And I did note that you may remove the pretrial scram as of this date, since we're going to impose the sentence on you today.
Beach Life Salt Air.
Thank you very much. To your scram provider to have it removed.
Thank you, Your Honor.
Okay.
As I indicated, you'll have until June 3rd to get the written proof provided, and you have to start the EHM by May 13th. All right.
Thank you.
She seems pretty happy with the outcome.
Mr. Clark, did I miss anything?
Update in the Hannah Payne.
Mr. Kean?
Your Honor, I think that covered everything.
All right. Good job.
All right.
Good job. Good job. They're done. The Hannah Payne filing, we talked about that. We read the letter, or we watched the video. But the lawyer for the state, the prosecutor for the state, filed a motion in that Hannah Payne appeal that included like 5 references to case law that did not exist and quotations from those cases that also did not exist. And they got called on it in front of the Supreme Court, or in front of the appellate court. Might have been Supreme Court. And they're like, we have no idea why I didn't do that. And they're like, yeah, actually you did. And they're like, I'll file a amended, an addendum. I'll file, a new copy for you. And they did. They filed the new copy, and I looked at it. Basically, they deleted every single reference to all those case laws that don't exist, and then just added the part that says, we don't need to put any case law in because our argument stands alone on its merits. Boom. Terrible. Terrible. No case law supporting anything they're saying. So, absolutely wild. I'm copy-pasting a ton of photos I scanned out to a thumb drive for my kids. Decided to give them now instead of Christmas. Oh, that's awesome. Pictures are great. It seems very interesting to see whether Georgia Supreme Court will punish her and how, and whether or not Hannah gets a new trial, honestly, if this improves the odds at all for her getting a new trial. Let's see if we have anybody else that will be fun to watch here this afternoon. Let's see. I haven't popped in Judge McBurney's trial for a while. It's a little loud, but let's listen and see what he's doing.
Drug allegation moving along with the burglary. Ms. Wood is hoping to have this be a conditional discharge disposition, but that requires some connection to drugs. And I'm going to let her articulate that when it's her turn. But what did your review of the police report say about whether they found actual drugs or it just smelled like drugs were there?
Yes, Your Honor. In addition to smelling the marijuana, the officers did find and weighed 74 grams of marijuana that was in the home on that countertop that was also located closely to the ID found that was that matched the defendants.
Got it. Okay. Thank you.
74 grams. How much is that?
Ms. Stallworth, good afternoon.
Good afternoon.
Can you share what criminal history you've got on Mr. Stringer, please?
Yes, Your Honor. He has 5 cycles total. There appears to be an active warrant out of East Point. for a flight to avoid. The date of that warrant was February the 17th of 2026.
Pick him up.
And I also saw the first offender probation for aggravated assault and possession of firearm or knife during commission. That's all.
Are you sitting on your mom's bed?
Thank you so much. Ms. Wood.
In court?
Yes, Judge. So, Mr. Stringer, as you heard previously, he was represented by different counsel when he took the aggravated assault plea. And so that's one of the holdups we've had with this case is that he was concerned about this case being a problem with his case for that. But of course, these warrants now will present a different issue for Mr. Stringer. But I would just ask for the court to consider sentencing him under 1613-2. There was marijuana usage involved. I think 74 grams is, and the smell of marijuana is enough to know that there was marijuana use involved in this crime. So we would ask for conditional discharge. Otherwise, I don't know that he's had any issues with probation. I think he is a good candidate for this sentence. So we would just ask that you accept the state's recommendation.
All right. Ms. Simpson, is there anything in the system about probation troubles for Mr. Stringer? He's doing his GED, which is good. That was one of the requirements. He hadn't been on all that long. It was a plea in September, but we got 6 months under our belt.
Yeah, he has filed an abusive environment without his conditions still so far.
Okay. Got it. Mr. Stringer, do you have any questions about the things we've been discussing?
No, sir. No, sir. I'm listening. I
know you're listening.
I didn't know anything about no warrant though.
Okay, I'll get to that. I'll talk to you about that in a minute because you're going to want to address that. So this situation that we're here for, Christmas Eve 2023, this house on Baldwin Circle, was that where you were staying at the time, or was that just sort of like a hangout?
No, someone actually sold me the home and gave me a lease. I signed a lease. That's why I told them when they came in the house, like, yes, someone is here.
Oh, you're saying that someone represented that, hey, I've got this place you could rent. And
yeah, you get what I'm saying? I was 19 years old. You get what I'm saying? So I'm just trying to get my own home. You get what I'm saying? I don't.
How much did you pay?
I gave them $7,000 cash and met them in front of the home.
Cash money.
Like,
wow. How did you have $7,000 as a 19-year-old?
I was just working. I always had a job.
Hustling.
Like what I'm doing now, I drive box trucks.
Okay. Next time, don't give anyone $7,000 cash. That's my free advice to you.
I learned that when that's what my public defender told me. Like, and I sent her even the lease and all that. Like, you get what I'm saying? Like,
okay, I'm hearing you, and that's probably why this didn't go to trial and why you got this offer, even though there's been some other things going on. But some things are too good to be true. And someone's saying, "Here's this great house. Just give me a bunch of cash, and it's all yours." And it wasn't even theirs to let you be in. I'm glad no one got shot. I mean, it sounds like that guy drew down on you because he didn't know who was in the house.
Scared me. This is why I'm showing them my phone. Like, look, this the lease. Like, someone sold me this home. Like,
yeah.
So that's what just had me like leave because I was in fear of my life of being shot. Like, I didn't. You know what I'm saying?
I know what you're saying. And so I want to see if I am correct. You staying at Lull Place now?
No, sir. That's an old address. That's the old address.
I've shared his most recent address with Ms. Simpson.
Okay. And I don't really need to know the specifics of it other than where are you staying? Are you staying with family? Do you have your own spot? Did you give someone $5,000 to live there, or what's the deal?
No, I'm staying with family right now.
Okay. And is that a stable place for you? Because probation needs to be able to find you. You can't be bouncing from couch to couch.
Oh, no. I already called in, did my monthly check-in and changed the address. And also talked to my probation officer about the address, too. She knows. Like, it's a family member, my cousin. She's also on my emergency contacts, too.
Okay.
So, yeah.
What is your probation officer's name?
Officer Yancey.
Okay. All right. That's good. You know her name. And she has your phone number?
Yes.
Okay. Well, good. He reported today. All right. They must not have run his warrants. All right. Mr. Stringer, let's take care of this case first. I find there's a factual basis for your plea. You had a good defense. You had a lease, but it turns out not to have been your place. I think this is a very reasonable resolution. So I'll accept your plea. I find that your plea is knowing and voluntary, meaning you've understood what we talked about, and if you didn't, you asked. And it's voluntary in the sense that no one is forcing you, twisting your arm to take the plea, but you've decided it's in your best interest to do so. Is that correct?
Right.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, can we sign for you?
Yes, Judge.
Mr. Stringer, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes.
Okay.
Can I also ask the public defender a question too?
Sure. Why don't you ask the question like this, and then if she needs to answer in private, she can give you a call.
Okay.
Or do you not want me to hear the question?
Is it about this case, Mr. Stringer?
Yes.
Okay.
It was mostly, I was just asking just to make it make sense to myself. Like, okay, like what I just explained to you guys, right? Do that make the most sense? Like with me pleading guilty, like basically saying I did burglary when honestly I didn't.
So it's a great question, and it makes sense to work your case out if you think working your case out is the right idea. And it would be an interesting legal question about whether you committed burglary or not. Mr. Smith would say you did, that you were in his house without permission. And I think factually that's correct. But you were in the house with the permission of the person you thought could give permission. And so you'd have a great defense, and a jury would have to wrestle with that. Like, well, was this just a mistake on Mr. Stringer's side?
Take it to trial.
Or what? So what you are doing by entering this plea, and I should be clear, I'm going to accept it as a conditional discharge plea. So it's technically not a guilty plea, and it's not going to be a conviction on your record, just like this first offender, because it's kind of connected to you having the weed that you had in there, et cetera. But I think I understand your confusion, but I can also understand why you wouldn't necessarily want to go to trial. Based on what was found in the house, the jury might think, wait a minute, you did what? You paid some money to be in there, and were you operating this as a marketplace or who knows what? So I think there's some complications for you in the case as well. And so I can understand why you'd want to try to get this conditional discharge. But I may not have answered your question, and you may have wanted to hear from your lawyer. Do you want me to have her give you a call, or are you okay going forward?
I'm okay with going forward.
Okay. So I am going to accept this as a conditional discharge plea, which is a whole lot like first offender, which means if you manage not to screw up while you are on probation, then this can slide off your record a few years down the road. But there's stuff riding on it, just like the other case. If 6 months from now you get arrested for something new, that's going to be something that is a problem for you. These things that were in your past are in your past. You don't need to worry about them so much. This new warrant will have no effect on this case. The new warrant may be a little complicated for the case you pled to in September, but we're not working that out today. You don't even know what those charges are all about. I'm going to sentence you, Mr. Stringer, to 5 years to serve 1 month with a balance on probation. You're not going back into custody. Special condition of probation number 1 is that you complete your GED. That's already a requirement in your other case. Special condition number 2 is that you stay away from 163 Bowen Circle. Is that, I don't know how far that is from either your grandmother's house or your cousin's house. Is it far away?
Yeah, it's in the area. You know, Atlanta is small, so it's in the area, but
Atlanta's small?
That's a neighborhood. Like
his lawyer's
my grandmother stays all the way on the other side of,
Okay. Atlanta's small, but I would not want to walk from East Point to Alpharetta.
I don't even walk.
Yeah, so don't go near Bowen Circle, okay?
Understood.
All right. Also, no contact with that guy who pointed a gun in your face, Chad Smith. Don't go near him.
For your own good.
No.
Good. Shaking his head. And finally, you are going to, and probation will help you arrange this, You're going to meet with some medical professional and have a drug and alcohol abuse evaluation. And if that person concludes based on you being real honest with them, like, hey, you know what, I drink a little bit of this or I smoke a little bit of that, you may have some drug treatment woven into your probation. But if that person says there are no issues here, then you don't have any treatment. I am adding that only to help you if you need help in that space. And you may not need help in that space, in which case it's an easy evaluation and nothing flows from that. Ms. Smith, anything else in Mr. Stringer's case?
Nothing further. Thank you.
Ms. Wood?
Only Judge, I might have missed it. So he actually served 24 days. I just want to make sure that the paperwork, that the jail doesn't say, oh, he owes us 6 days.
So it's a good question. I've never had the jail come running after someone saying, where are those 6 days? If he were still in custody, then we'd need to talk about it because it would probably mean he'd do 6 more days. I think we're okay. If not, someone just needs to let me know.
Perfect. Thank you.
Here's where you're not okay, Mr. Stringer, and you are going to want to talk to your probation officer or talk to Ms. Wood, not right now, offline. But you do have these 5, I'm going to say 5 warrants. Don't panic. It's all one incident, but there are 5 warrants listed because it's different allegations relating to the one incident. And let me pull it up. I'll give you a little bit of information. So something supposedly happened on February 13th in East Point. Seatbelt violation, not obeying either a red light or a stop sign, changed lanes, reckless driving, and then the police say they tried to pull you over and you didn't stop right away.
It was a pursuit.
I don't know anything more about it than that, but there are 5 warrants all related to this one thing with your name on them. And you want to get out ahead of that because if you get stopped for some other reason, they're going to run your name and these will all hit. And that leads to a much more complicated encounter with the officer. So probation, you could talk to Officer Yancey and say, hey, what's the best way to deal with this? And she might say, you got to go to East Point or wherever these warrants are from. Ms. Wood might be able to get a sense of what to do with it. I can't give you advice other than you need to take care of these things because they're going to be rattling around out there and you do not want them to catch up on you. You want to go deal with them. Does that make sense?
Understood.
Let me see if I can get it won't let me open the document. I was going to try to get you some kind of information beyond that, but I can't. It's just those warrants all from that date. And I think Ms. Stallworth said it was out of East Point. So follow up on that, okay?
There's one more thing,
Understood,
Judge.
Sir.
What about reporting instructions?
April 10th, 8/9.
Okay. Mr. Stringer, you should write this down. And Ms. Wood may shoot you a text about it as well. But you need to go. You know where the probation office is?
Yes.
Where is it?
It's right there next to it's right next to the train station. The train station right there by Underground.
Okay. I'll say it's kind of like that.
Like
It's
14th Street. Like
it's on Memorial Drive.
Yeah, Memorial Drive, yeah.
I'm going to send you the address, but you need to report there on April 10th at 9 a.m. 9:30? 9:30. On April 10th at 9:30. I know you already have Officer Yancey, but you have to, I'm going to call it register for this new case as well. And you'll end up with just one officer, and it'll probably still be Officer Yancey. You don't have to report twice because you have 2 cases, but you have to do intake for every case that you've got. This is a new one. So you got to go to that office on Memorial Drive and do your intake and go from there. Okay?
You said April 12th?
Nope, April 10, 1-0.
April 10, sorry.
Yep. Next Friday, 9:30 at their offices.
Okay.
All right?
Yes.
All right. Give my best to your grandmother.
Say hey, Grandma.
Thanks, you.
All right. Grandma, keep him out of trouble.
Okay.
There's one more thing.
Yeah. You are banished. She had a cane. She could whack you on the head with that. Tell you to do right. Okay, Mr. Stringer, good luck with everything.
All right, thank you.
You are banished from the state of Georgia. You are banished from the state of Georgia.
I love that sound.
Okay, Mr. Wallach, if you had a chance to go back there, Can we bring Mr. Williams out? You see it? Great. Yeah.
Williams. Have we seen Williams before?
So hopefully that goes way back in time, but I don't think it would be a long transcript, but they need it for, he's competent again. They want to move forward, and that's become an issue.
Love Judge Bernie.
Stacey Williams. We want Stacey Williams.
Does you want us up at the podium, on the table?
I'm fine. Podium or even by the door if it's not a long talk, but podium is fine. Why would we do podium? Just because we're going to have a little bit back and forth about how to check out the evidence.
The first case he did that.
You got it. Excellent. Okay. Thank you. Hey, Mr. Williams, come on up to the podium and stand in front of the screen, please. All right, Mr. Wallach, we got to cover two things this afternoon with Mr. Williams. One is whether you're going to waive arraignment.
We are, Judge, and I went ahead and filled out the form that you pointed to. And
excellent. If you'll give that to Deputy Gordon, he'll get it to me, and we'll get it filed. Thanks for coming by, college students.
Oh, thank you. We'll be right back.
Okay. All right.
We're just going to have to smoke some weed in the parking lot.
So we took care of arraignment. Mr. Williams, the state superseded the indictment. Mr. Wallach told you what's changed. One count went away, et cetera. The other thing we need to work through is enabling Mr. Wallach and Mr. Williams to spend more time together, and you, Mr. Williams, to be able to review digital evidence. The sheriff's team has told me they would prefer transporting you here, and when we're down some morning or afternoon, have you sit right there with a laptop and watch the video rather than having the law library exclusive to you and you handling digital media. Their preference from security and staffing was to do it the way in the past I thought they didn't want, which was to use transport, but they were very specific. And you're welcome to be here, or an investigator can be here.
So, and obviously not disputing what they told you, what they told us was we could do it on a flash drive and he'd have access in the law library.
Right.
So, which is why we requested it that way.
And it was a great request. And so I went to the tippy top and said, I've not really had a request like this. I want to do it the right way. And the answer I got was, we will not fuss at you. They used to fuss at you. Brought someone over so they could watch it. Let's do that at the jail. Staffing levels are different now, I guess. And so
with that in mind, because that goes to one of the other requests, do they prefer that if I need to meet with Mr. Williams, or my team, my investigators do, and we need to meet with him in what we call a contact visit, which means not through the glass where we can't hear each other and couldn't really play a video and talk about it and go back and forth. They want us doing that here.
I asked that question as well.
They want that there.
Yes, but that would be, if that's the only thing you're doing, it would be there, because you have the additional request of Mr. Williams reviewing digital evidence solo, because often the lawyer says, I want to watch it with, or my investigator is going to watch it with. That's a contact visit there. But if he's going to watch it solo, the answer I received is then we'll bring the inmate here and he or she can watch it in a private courtroom. No one else is in here, et cetera. You may want to combine the two. And if you do, you are welcome to do it here if that's your preference. And that would just mean coordinating schedules, because it would need to be a morning or an afternoon when I don't have court out here. And so that's why I wanted the three of us to be talking about it. You can do both. You can, I just haven't signed the contact visit order yet because I wanted us to have this conversation. If you want to have the order in place where you can flash it and that gets you and a laptop into a conference room with Mr. Williams at the jail, I'm happy to sign that. I don't need to sign an order to have Mr. Williams come here. I just order him up, but I would need that flash drive and some device on which to watch it, which would mean you or an investigator would be here anyway. So query, do you also then want to do the jail one? I'm open to whatever. I'm just going to follow the request of the sheriff because they do great work for us and they are thinly staffed.
Right. No, I appreciate that. And I appreciate you clarifying the way that they want it, because that's at the end of the day how it has to get done.
Amen.
So if
Can I get an amen?
To have Mr. Williams here, whether it's meeting with me or the investigator or on his own or whatnot, coordinated through your office?
Yep, you'd reach out to Ms. Nelson and she'd look and say, hey, Tuesday afternoon, we don't have court. And so we'd make sure that Mr. Williams is brought over. He'd be brought over on the morning bus. But then once we're done with court, Deputy Gordon will get him, bring him up, and then he just locks the courtroom. He can be in his office and there's no one in here other than if you were going to be here or an investigator, but it would be, we'll call it defense team only. Okay. And that can serve both purposes. Mr. Williams reviewing it by himself or you or an associate being here with him.
And in terms of contact visits at the jail, I assume based on your conversation with them, you have what you need in terms of language for a proposed order for that.
Yes, I just needed to know if you also wanted that. And that's why we're talking, because you might have said, oh, come here. I'll just soon be here and not out there.
I think I would, and I think that would give me the ability to see whether that actually works. And if it does, we may not need to bother you, or maybe that's not as effective and we do need to bother you a little bit.
Got it. So I will do the contact visit order. And that's not for a specific date. It is an authorization. And then you coordinate with the folks at the jail. They give you the windows that work or don't work. You've done that before. I don't know how that flows, but I'll do that order. And then I'll wait to hear back from you if you then want to supplement that with having Mr. Williams come over here to look at stuff, because he said, look, I need some time alone with this, or you only have an hour, but it's a 3-hour video and he wants to see the rest. That might be something we do over here, but I will stay out of it unless I hear from you.
All right,
this
terrific.
judge,
well, thank you.
This judge is in Fulton County,
the other thing that your
Georgia,
lawyer and the prosecutor and I discussed is scheduling. Today was supposed to be a final plea date, which was the last day you could enter a plea if you were interested in entering a plea, and have the ability to withdraw that plea if that's where you were going with the case. That's not happening for 2 reasons. One, this new indictment resets a clock, just 10 days worth, but I wouldn't make you think through this new indictment so quickly. But also Mr. Wallach has asked that I take your case off of, it was on 2 not quite overlapping trial calendars. One starts on Monday with a senior judge who comes in and helps us with cases. And then the one I have starts in a couple weeks. And Mr. Wallach indicated that he will be more effective and more prepared to do the work he needs to on your behalf if there was a little more time in there. And so I didn't remove them. They're still printed on the calendar, but they're continued. So you will not come back here for the call of this upcoming trial calendar per Mr. Wallach's request and an order that I entered granting that continuance.
Yes, sir.
I'm sure you guys talked about it, but I wanted you to hear it from me so that you're like, wait, why am I not coming back to court? I told you why, because your lawyer asked for it. Okay.
I told
Ms.
you.
Nix, anything we need to hear about from the state in connection with Mr. Williams's case?
No, sir.
Okay. Have you, today was going to be final plea. Had you communicated an offer to Mr. Wallach, or because you knew you were going to supersede, you guys didn't get there?
I did send an offer.
Okay, excellent. Well, I'm glad that those conversations are happening. I'll take care of the contact visit order and we'll go from there.
Terrific. Thanks, Judge.
You bet.
You are banished from the state of Georgia. This is the only Georgia judge I like. He's really good, Judge McBurney. Occasionally we get to see his face on this channel. I'm just really pleased that earlier this year he had some texts come in and adjust his audio levels.
So can we do Mr. Mann? This is Mr.
Took
Mann?
his voice down just a little bit.
Can we do Mr. Mann now? Okay, great.
We'll stick with him for just a minute and see what he's got going on. It's a very patient judge. You have a mud dauber.
Mr. Mann, if you'll come on up and stand in front of that monitor there, please.
To get rid of the mud daubers.
I'm sorry, there are 2 monitors. Stand by your lawyer.
Stand by your man, lawyer. Stand by your man. Stand by your man. Isn't there a song about that? I am the man. The gosh dang paterfamilias. All right.
Let me know when you're ready.
Tell me why not. We're ready, Judge, when you are.
Ready, Mitch Rivers? Okay, we're gonna go on the record. This is State versus Mann, 25 SC 005722.
State's gonna
Mr.
stick
Mann
it to
is
the
here
man.
in court with his lawyer, Ms. Wood, and Ms. Willingham is representing the state. Mr. Mann, Ms. Wood tells me, and you heard her say it, that you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay, I'm assuming something is changing with how it's indicted?
Yes, Judge.
Okay.
And if you want me to go ahead and put that on the record now. Okay.
No, I just was, I'll let you get that on record in just a moment. Mr. Mann, in a moment, Ms. Willingham's going to put you under oath, and then she's going to ask you a bunch of questions. You heard most of them in a plea you just listened to. They're going to be similar, but they're going to be tailored to you and your charges. You need to answer those questions, but you also need to let Ms. Wood or me know if you've got questions of your own. If something's confusing or you didn't understand what someone said, will you tell me?
Yes, sir.
Okay. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Perez Allen Mann.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Yes.
How old are you and how far have you gone in school?
43, GD.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment?
I do.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Mr. Mann, do you understand you are entering a guilty plea to the following offenses? As to count 1, kidnapping, the state will be reducing reducing that charge to aggravated assault under 16-5-21, which has a minimum of 1 year and a maximum of 20. As to count 2, criminal damage, and I'm sorry. As to count 1, the sentence recommendation would be 5 years probation. As to count 2, the sentence recommendation would be 5 years probation to run concurrent with count 1. And as to count 3, the sentence recommendation would be 12 months probation to run concurrent to count 1. And the parties have agreed that counts 1 and 3 will not merge in this instance for the purposes of the negotiation. And there would be no contact with the victim, complete family violence intervention program, complete 60 hours of community service.
Remember in the beginning when we started 110 years ago?
And maintain gainful employment. Was this explained to you by your attorney?
Yes, ma'am.
And do you understand that this is a negotiated plea of guilty? However, the court can sentence you up to the maximum sentence of each of these charges, and they can run those sentences consecutively or one after the other?
Yes.
And do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand? I'm sorry, are you on probation or parole for anything, anywhere?
No.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you could be found guilty of another felony?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
You're fat and guilty? What? Oh, facts.
Yes.
Facts.
Yes. Yes.
How do you plead to the reduced charge of aggravated assault, the charge of criminal damage to property in the second degree, and battery in indictment 25 SC 005722?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on October 5th, 2023, officers with South Fulton PD responded to a domestic dispute at 4422 Estate in South Fulton County. Upon arrival, officers spoke to Ms. Jamaica Johnson, who advised that her boyfriend, Mr. Perez Man, got angry over a social media post and hit her in the face so hard that she lost consciousness for a moment.
Whoa.
When Ms. Johnson tried to get away and go inside her home, he grabbed her by her hair and dragged her against her will into his car and drove her to a home in DeKalb County.
That's kidnapping.
Ms. Johnson had to contact a friend, Ms. King, to come pick her up and call 911. When Ms. Johnson was able to get back to her home, she noticed Mr. Mann damaged her 70-inch TV and put a hole in the wall. Warrants were obtained and the defendant was later arrested. Your Honor, I have had an opportunity to speak with Ms. Johnson, and for the record, she is not happy with the state's recommendation in this case. However,
in which direction? She thinks he should go to prison, or she thinks you should drop the case?
She thinks that he should go to prison. However,
what?
In further review of this case, it is also our understanding that Ms. Johnson stated that she also contacted law enforcement in DeKalb County. She said that DeKalb County did arrive to the home. However, they told her to go back to Fulton County and contact law enforcement there. Based on some of our investigation, although we do not negate that call was made, we share some of DeKalb's concerns as to why they did not make an arrest at that time. As Your Honor recognizes, that a kidnapping charge would be a continuing crime. So there would not have been a reason for them to not arrest the defendant at that time. It is our understanding from speaking with the victim that she arrived to the home with the defendant at the same time as her friend and law enforcement. So that also drew a bit of concern for the state. However, we do not have any reason to have hesitation as to what happened outside of Ms. Johnson's
the
home.
assault and busting up the TV.
Yes.
So you don't believe her?
As officers were able to see that her TV was damaged, that Ms. Johnson did have injuries to her leg, where she had some scrapes on her leg that were they weren't small scrapes. And she also had some braids missing out of her hair. So we have no doubt about the aggravated assault, the criminal damage, or the battery. We just do believe that the kidnapping may not have been as strong of a case. Not to say that Ms. Johnson did not feel that she was unable to leave or that she was taken against her will, just that we recognize some of the hurdles we would have in presenting that charge to a jury.
Has she shared any concerns about Mr. Mann not staying away from her? This is now 2.5 years, and that's a great test to see if Mr. Mann is going to comply with Ms. Johnson needs to be able to lead her own life.
So they were
test with her as the bait?
Still together up until based on our notes, it looks like about a year ago is when we can say there was for sure no more contact. Okay. But since that time, she has not said, when I spoke with her the other day, she has not alleged that the defendant has made any communication with her. She obviously wants that no contact to remain in place. But
the contact that happened, say, in 2024, would have been contact that she consented to.
Yes, Your Honor.
Okay. All right. Thank you. That's helpful. Mrs. Stallworth, do you have any criminal history information for Mr. Mann?
I do. He has 23 cycles total, 11 from the state of Florida, 1 from federal. There is an 01 conviction for trafficking in cocaine. And then there was a 2021 FTA out of Avondale. Nothing further.
So 1 conviction, and it's from way back in 01.
That's what I saw, yes, Your Honor.
23
Okay.
cycles.
What was the federal cycle?
I think it might have been the trafficking. Let me check.
This is nuts. We didn't actually witness her while she was kidnapped. So the fact that her hair was ripped out of her head, she had cuts on her arms, her TV was smashed, and we saw her get out of the car and run to police officers.
Sure. It was
Just
a
not a strong
professional
enough case.
I caught a track when I was like 17, and I turned kind of like an adult in prison. Then right after that, like 3-4 years later, I got caught with a firearm. So they sent me to the feds for being a felon with a firearm.
Okay. Just 1 felon with a firearm, but it went federal.
Yeah.
Was it here in the Northern District or in Florida?
I caught it. I was living in Florida. I caught it in Alabama.
Okay.
And Alabama sent me straight to prison after that.
Well, there you go.
The cycle here is showing for a probation violation through the U.S. feds, but for the transport of firearms.
Okay. Thank you.
You're welcome.
This is nuts.
Ms. Wood.
Yes, Judge. So he did 26 days in Fulton County Jail for this case. He's 43 years old, as you heard. He does have his GED. He's starting a new job this week. Tomorrow. He's a chef by trade.
I lost my jobs because of the kidnapping thing, so it's been hard.
And so we appreciate Ms. Willingham working with us on the charge change so that he can hopefully maintain this new job that he's getting, Judge. I did want to let the court know, so he does have 2 children. One of the kids is with the victim. However, he is aware he's fine with the no contact. I think that he has actually had no contact.
Yeah.
He's never met the baby.
Even with the kid, after I went through this, like, I don't even know what to say. I don't know what to do. I just don't want to be around it.
I've advised him that if he should change, that needs to go through family court.
Yep.
And so he understands that, Judge. And lastly, he is asking the court to consider setting a behavioral incentive date for this case.
Okay.
Let you out on good behavior.
Where are you going to be a chef, Mr. Mann?
I start at Mission Burger tomorrow.
Where's that?
It's like Howell Mill. I was a chef
Mill's long. What's it near? It's just on Howell Mill.
Yeah, I'm sorry.
That's okay.
Yeah.
Mission Burger. How'd you get the job?
Through a reference. That's actually my old boss came with me at my other job.
Okay. What was your other job?
I was just chef at the Battery.
Okay.
Yeah, I was a great chef there.
I bet you're a great chef wherever you are. Yeah. Why did you shift from the Battery to Mission Burger?
They don't like
I got a promotion to another restaurant called Walk On. They promoted me and offered us a lot of money, and then it didn't end up working out at the restaurant.
Okay. So Mission Burger it is starting tomorrow.
Because of the kidnapping thing.
Okay. And is that actual like beef, or is Mission Burger it's made out of chickpeas?
It's all vegetarian restaurant.
You all right with that?
I'm from losing pounds. I'm gonna learn.
All right. Good. Mission Burger it is. So you have two kids, one with a different woman than Ms. Johnson.
Yeah, my son, he was coming to live with me and Ms. Johnson back and forth from Florida.
Okay.
So I kind of ain't let him. The first move I got, I ain't know how to talk to him because everybody familiar with the case, the family. So it just.
How old is your son?
He just turned 18.
18. He's a big kid.
Yeah.
Okay. He goes where he wants now.
Yeah, he like me though.
Okay. And is he in high school? What's his
He just graduated.
Congrats. What's he going to do?
He doing music and he want to take a trade. And I'm with him whatever he want to do.
Is he based in Florida? Home is Florida?
Yeah, kind of back and forth.
Okay.
He come live with me and live in Florida.
Okay. And what county do you live in?
Douglasville.
Douglas County?
Douglas County, I'm sorry.
Okay. That's okay. All right. You got, looks like it got dismissed, but you had an arrest or something in May of 24. Failure to obey traffic sign, possession of cocaine, a couple other things. Did that go away?
Yeah, the cop pulled me over and he found a baggie and charged me. It was some more people in the car and then ended up going to court. They threw it out.
They threw it out. Okay.
Yeah.
Got it. Okay. Do you have questions about any of the things we discussed?
No, sir.
Okay, well, I'm going to accept your plea, Mr. Mann. I find there's a factual basis that you and Ms. Johnson got into it in October of 2023.
Yes.
You did some things that a big guy needs to not do to someone, which is why you'll do the Family Violence Intervention Program.
Right.
I also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about, and that no one's forcing you to enter the plea. You agree with that?
Yes, sir.
All right. Ms. Wood, can someone in my office sign the indictment?
Yes, Judge.
What's the
Ms.
sentence,
Willingham?
Judge?
Yes, Judge.
And can we sign it for you, Mr. Mann?
Yes, sir.
Great, we'll do that.
For the assault?
So here's how I'm going to sentence you. On count one, I am sentencing you to 5 years to serve 1 month. You actually did, if you add up the two different stints in 35 days, a little more than a month. Mm-hmm. So 5 years to serve 1 month with the balance on probation. Count two is going to be 5 years to serve 1 month, balance on probation. And then count three is 1 month to serve. They all run together. So total sentence, 5 years to serve 1 month. So you've got 4 years and 11 months probation.
Yes, sir.
Special condition number one is leave Ms. Johnson alone. No contact. Don't call her. Don't write her. If in your heart you find, I want to spend time with my little baby, like Ms. Wood said, then you're going to need to go through the courts. If you're the biological father, you have certain rights to be with that child.
Yeah.
But you can't just call Ms. Johnson up and say, hey, I need to see the kid.
Right.
Because that's you contacting Ms. Johnson.
Right.
And it sure sounds like she's going to call Ms. Willingham right away and say, guess who just called me?
Yeah.
And then we're going to be back here and you're going to lose your job at Mission Burger. You're going to say, that's fine. I didn't like chickpea burgers, but you go to jail and that will be bad.
Right.
So no contact with Ms. Johnson.
Yes, sir.
You'll complete a family violence intervention program. That's not one class. It's a series of classes, but they're good classes and you'll learn from them. Mm-hmm. You need to enroll in the family violence intervention program within the first 3 months of probation.
Okay.
So not tomorrow, not next week, get settled with your job, but within the first 3 months, you got to start those classes.
Yes, sir.
You also need to, within the first year of your probation, complete 60 hours of community service. And since your only other conviction is from 01, I will set a behavioral incentive date. It will be April 1 of 2029. So that's 3 years from now.
Okay.
If you have done everything you need to do, taking your classes, stayed out of trouble, left Ms. Johnson alone, then a couple of years early, probation can say, hey, Mr. Mann is squared away. Heck, by then he's 45 years old. He's working. Let's let him go his own way.
Yes, sir.
So you control that one. If you're a pain in the rear and you aren't showing up for meetings or this or that, then they'll say, hey, we'll just do the full 5.
Yes, sir.
Ms. Willingham, anything else on behalf of the state?
Nothing from the state, Your Honor.
Ms. Wood?
No, Judge, thank you.
Ms. Simpson, what are the reporting instructions for Mr. Mann? He will be reporting in Douglas County. I don't know where he goes for that.
Okay.
Yes. Reporting date will also be able to.
At 9:30 a.m.?
Yeah, thank you.
8 a.m.
8 a.m. Wow, they start early in Douglas County. Okay. Mr. Mann, Ms. Simpson's going to meet with you in just a minute. She's with probation, but she is putting on the record that your reporting date for probation is April 10th. That's next Friday, not this Friday, the Friday after at 8 a.m. At some place in Douglas County. She's going to tell you where. You don't have to guess.
Okay.
But that's your kickoff appointment, and they're going to be waiting. If you don't show up, it's 9 o'clock. They just send me a warrant to sign. We say, Mr. Mann didn't even show up for his first meeting with probation, so don't miss that. That's a hot date.
Yes, sir.
Okay?
Yes, sir.
All right, good luck.
Okay.
All right, thanks.
Wow.
Judge, that concludes my business. May I be excused?
Yes, ma'am. I'll see you around. Thank you.
Yeah, actually, the receipt is thing. I actually didn't realize that draw on chart.
Yes.
That was why I was so confused when you were saying that, like, I literally ran out of people.
Oh.
Y'all had to show me how to do it.
Yeah, you pick and choose. Yeah, good.
Let me just say, stay out of Georgia. Good grief. Let's just recap for a minute. This guy, Mr. Mann, 23 prior cycles, one of them federal. A cycle is when you pick up a charge and it goes through the system and you have a sentence or, probation or something attached. That's a cycle. That's one cycle. 23 of those. Draws this charge. Kidnapping is what was sort of pressed. That was the charge. His baby mama, I guess, for lack of a better word, has dreadlocks pulled out of her head, ripped off of her head, scratches, long scratches on her legs. These two things are consistent with being dragged by your hair somewhere where you probably don't want to go. Her TV is smashed in and she got hit in the face so hard she briefly lost consciousness. This woman calls a friend to call 911 saying, I've been kidnapped, I'm being held against my will. He decides it's time to release her, shows up with her at the same time the friend and the police arrive, and the police say, yeah, that kidnapping charge, it's going to be hard to prove in court. Let's just let him plea down to probation and time served. What the actual? This is so bad. And what was the federal charge? Oh, I picked up a felon with a firearm charge, Alabama, you know how they are. They threw me right in prison. I got this felony distribution, cocaine, and then, they caught me with a gun and, what? 24 is not his last cycle. 24 was not the magic number. He has not suddenly matured and changed his ways. This is a pattern. And at this point, for the court to be looking at like this is a first offense, just a simple assault, kidnapping charge, it's probably didn't happen. Had two police officers who, two agencies looked at this and didn't take him in. They're just, so hard to prove those things. You've got the hair ripped out of her head and the bloody scratches on her legs where she was dragged, and the smashed TV, and the fact that they were together and the friends witnessed. Yeah, there's just no evidence to support that. What? Georgia, do better. Do better. What do you need? Do you need to witness it happen? Do you need the officer to be kidnapped in order to say, yep, it really happened? I was there. It was kidnapped me. That was bad. The victim wants to press charges, wants to pursue it, and is livid, and rightfully so, that the state is like, yeah, we're going to do a plea deal. Plea deal. Yep. He's gonna be out this afternoon. Yeah, just a quick stop by the judge, say sorry, you look down sheepishly, and the judge will pat you on the back and give you a kick in the butt and say, okay, now be good. And now he's out. That's not good. That's no bueno. No bueno. I think I'm done with Judge McBurney. I don't think I can take more of that. We're hoping to go to with Judge Stephanie Boyd this afternoon. She's got a jury trial that should be starting here in just a couple minutes. Josh, do we know how many minutes we've got? It's hard for juries in Atlanta to convict. I hear that, but man, for the state to just roll over and play dead instead of prosecuting, at least go through the actions. Hey, Judge.
Who's the attorney? All right, if you come forward.
We're live with Judge Boyd right now out of San Antonio, Texas.
Sean, this is an application for deferred. Court is calling 2026 CR 000422, State versus Lucio Sodto. Can I have parties announced?
Sodto.
Robert Ramirez from Mr. Sodto, Your Honor.
And are you Mr. Sodto?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sodto, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney?
Yes, ma'am, that's the waiver of like.
That's what you're charged
Dana.
with.
Yeah.
Dana,
All right,
thanks
counsel,
for
do you
saying
waive the
that.
reading of the indictment?
Have you
We
talked
do.
to your doctor
State,
about it?
are you proceeding on the indictment as presented? Mr. Sodto, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
All right, you're charged with possession of a controlled substance, penalty group 2, 4 to 400 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea, court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Sodto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Did you understand if I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,200 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State? Yes. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, the DOEP course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I did.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
And while she reviews that, Dana, thanks for saying something, first of all. Chronic pain and pain management is something that's very important. You can't just not manage pain and just say deal with it. Talking with your doctor is probably the first thing, and tell him your concerns. Okay, you're on some medication that you feel is, you might have some sort of addiction to, right, for lack of a better term. Talk to them. There might be other methods of pain. There might be other things you can take that might not be as severe. I know just stopping medication and trying to deal with the pain, that's not the right way to go about it. But there are ways you can treat this that can help, that can make to get you to a more comfortable place with what you're doing and feel good about the pain medication that you're taking. So thank you very much for saying something. I'm not qualified to give you the advice
evidence to find you guilty
on that.
Court will defer finding of guilt as you apply for
and don't feel ashamed
deferred
about it.
adjudication. Are you proceeding with sentencing?
You're doing exactly
Yes,
what you
ma'am.
should do.
Anything you wish to say on behalf of your client?
Your Honor, we ask that you follow the plea agreement.
All right. How old are you?
24, about to be 25 on April 4th.
All right. And who is Janessa Garcia to you?
My ex-wife.
And who is Ayden Salinas?
My mother.
Okay. And she was in the car with you?
She was the one who picked up my vehicle after I was arrested.
Okay. So do you have any children?
Yes, I have one son.
Age?
He's going to be 2 on April 20th.
All right. Does he live with you?
No, me and the child's mother have very many differences and been trying to go about it with the family lawyer to regain, that ability to see my kid, because I've asked police officers to help me with it before, but they always tell me that I need a court case and things of that such to be able for them to do anything. So I've just been kind of down on my luck money-wise, so I haven't been able to pay a proper family lawyer. So I've been trying to just get myself back on my feet for the last year.
And if you drug tested today, what are the results going to be?
Marijuana.
And when's the last time you used?
This morning.
2 weeks ago.
All right. So if you're trying to get your child back or have visitation with your child, a good place to start is to stop using.
Yes, ma'am. That's the biggest reason why I did accept the probation, is because it helps me stay on track to make the right decisions, because not only do I care about my freedom, but I also do want to change the direction of my life where it was going.
But here's the thing, probation is not going to be forever. And you need to do this whether you have probation or not if you want to be in your child's life.
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I work for Revamp Security. I'm a sales rep. So just a door-to-door salesman. It's a good job. It pays me well. It's commission.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, tests for levels.
Parenting classes.
There's to be a TAP evaluation out of custody, follow recommendations. There's $1,200 fine that will be probated. Field visits 1 time per month for 6 months. Proof of employment within 45 days. No employment as a home health care provider or with minors. 120 hours of community service restitution. I'm going to order parenting classes.
Bingo.
Once the parenting classes are complete, 100 hours will be deemed satisfied. The remaining 20 hours will be deemed satisfied upon completion of the DLEP course. Probation, is there anything else?
No, sir.
Is there anything else you need from the court in order to be successful?
No, I will say that the amount of resources that you're giving me will help me to go down the right direction.
All right. Well, make sure you stay in contact with probation, okay?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
While she completes this, it looks like she's accepting the deal. I just noticed the flowers she's got. Beautiful, beautiful yellow. It looks like yellow roses over there with a couple others there in the back. Sort of an Eastery feel as Easter's coming up. I like the pastels and all. Easter Sunday. It's this Sunday. That's awesome. I love Easter. It's a beautiful season.
Martin Guerra, what's happening with your case?
Judge, I conferred with the state. We have an offer. I had a suggestion or proposal, really. we can get a trial date quickly, but if my client so chooses and the state doesn't object, he can enter a plea on Zoom.
She doesn't
Well,
allow
first
that.
of all, your client has a warrant,
I know, Your Honor.
so that
Where
needs
is
to
he?
be taken care of. And I'm not going to do any pleas by Zoom with a warrant. And Norma, oh, sorry, let me do this.
Where's your client?
All right, Mr. Shepherd,
He is not on the line right now, Your Honor. I don't know if
can
he's
you
on.
call him?
Yeah.
The yellow rose is the state flower of Texas.
I'm here. All right.
Isn't there a song about that?
We can set this for trial Thursday or next week. When do you want it set?
Next week, Your Honor.
All right, Norma, set this for jury trial next week.
You have April 7th?
All right, your jury trial is going to be April 7th. You need to appear in court on April 7th.
In person.
All right, thank you.
Thank you, Judge.
Thank you.
Wow.
Who else has a plea ready?
Got a question for you. I'm trying to impress a
All right,
couple of
Robert
young
Bauer.
kids. I know that's easy to do sometimes, and also hard. I want to use science and tech to impress them.
All right, Mr. Cedillo, come down.
I'm thinking like one of those gyro balls that you hold in your hand. You spin it, and it lights up and spins really fast
All right,
with no
thank you.
motor.
Hello,
I think
all
that would
right.
work. Needs to look like magic.
All right, and probation, there are no applications.
Clever name. You got to dial it back and
Court is calling 2026 CR 001131, State versus Jose Cedillo. Could I have parties announced?
Megan Galloway for the state.
Robert Maurer for defendant.
And are you Mr. Cedillo?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Cedillo, did you review the true
plasma
bill of
ball.
indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do.
State, are you proceeding on the indictment as presented?
We're proceeding on the lesser included offense of possession of controlled substance, PG 1 plus.
Possession of a
That's our
controlled
understanding,
substance.
Judge.
Any objection?
No.
Mr. Cedillo, did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Court
State is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Cedillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Sorry, just 1 second. If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 9 months in the Bexar County Jail under 1244. There's an $800 fine. There are no applications. The state is taking in consideration County Court Cause number 719086, and they're proceeding on the lesser included offense. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and cite it in both places?
Here, can mute her. I'm thinking this, guys. I told you something fancy. It has to look like magic. It has to look like magic, and I think this plasma ball, if you've never seen one of these, there's an Ohio verdict. Should we jump to Ohio? We didn't follow the trial, but we could follow the verdict really quickly. Followed part of it. It's a glass ball that's safe to touch and does this little plasma light display. It looks just like it does in that video. I'm thinking, yeah, okay. We'll jump to Ohio real quick. That's on 7, I believe. Oh, 6. Here we go. Is this one we're talking about? I just need something that makes it look magic, and I think that would do it. And that's something they can touch as well. That's safe. So it's going to be guilty. Those jail calls were pretty bad. They were bad in that they had music playing in the background, so we had to mute it. We couldn't follow the case as much as we wanted to. They're also bad because it's his daughter that was on the other end of the line lining up that delivery, and the daughter is facing trial later this week for the same charges. She testified against the father in her case, and the one deal she got was that her testimony would not be used against her in her case. So it'll be interesting how she fights these charges when she goes to court, or if she gets any leniency because of her willingness to cooperate and implicate her dad. So verdict music for this one. I already summarized it. Mr. Kenneth Carney is going to find out in just a couple minutes what the jury thinks of his story, whether he is in fact guilty of attempting to smuggle in drugs. 50 grams of meth that were inside a Tide condom, inside a Cheetos Flamin' Hot bag, which was then deposited in the women's restroom trash under some paper towels. It was all convoluted mess that was arranged over phone calls to his daughter and some friends. The daughter showed up at the prison for visiting. Ran in, used the restroom, did not flush, probably didn't even wash her hands, dropped off the baggie, and then ran out of the building. The officers there thought it looked strange, went in, did a little investigation, found the drugs, were able to piece things together, pulled the phone calls, and were able to listen to hours of rambling phone calls where, in coded messages, the defendant arranged to have this 50 grams of meth delivered to him at the jail. It was going to be picked up by another inmate. How it would then get to this defendant, I don't know. But there were inmates that were cleaning the bathrooms and would have been dumping that trash. They would have been looking for that flaming hot Cheetos bag, knowing that inside there was fire. That was fire. 51 grams exactly. That's counting the condom. That's methed up. It's very methed up. It was so bad. How would he obtain the drugs? The other inmate would come grab him and then presumably take them out of the trash and smuggle them in. Don't ask me how, because I'm not sure if you want to know. Smuggle them into the prison. So, judge is here. Jury's coming in. Mics are going to be hot in just a second, so we'll turn down the music and listen to the verdict. Not nothing around. Nope. Lots of meth jokes here. We're still standing, so we'll keep the music going. All right. Perfect timing on that.
Thank you. Please be seated. Mr. Grubenhoff, I see you're holding the verdict forms. Are you the foreperson of the jury?
I am.
And now
Can
we
you
know
tell
your
me,
name.
has the jury reached a verdict?
We have.
Would you hand the verdict forms to Mr. Logston, please?
Defense said there was no evidence of purchase because this is the charge he was faced with. Involves for sale element to it.
In the matter of the State of Ohio versus Kenneth Carney, The verdict form as to count one reads as follows. We, the jury, being duly impaneled, sworn or affirmed, find the defendant, Kenneth Carney, guilty of aggravated trafficking in drugs as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. As to the additional finding to count one, we, the jury, find the amount of methamphetamine involved in the offense was equal to or in excess of 5 times the bulk amount, but less than the 50 times bulk amount. This additional finding is also signed by all 12 members of the jury. As to count two, we, the jury, being duly impaneled, sworn or affirmed, find the defendant, Kenneth Carney, guilty of illegal conveyance of drugs of abuse under the grounds of a specified government facility as he stands charged in the indictment. This verdict form is also signed by all 12 members of the jury. Does the state want the jury polled?
No, Your Honor, thank you.
Does the defense want the jury polled?
No, Your Honor.
Before I pronounce sentence, anything from the state?
Your Honor, the court heard the testimony in this case. The court's aware of the facts. The defendant has an extensive history of drug trafficking dating back to at least 2006. This was 51 grams of methamphetamine that he got his daughter with no criminal history to bring into the Warren Correctional Institution for him, and the court heard his testimony. So we would ask you to consider all of that and impose a sentence of at least 6 years.
Wow.
Mr. Brenner, anything on behalf of the defendant?
Thank you, Your Honor. I've gotten to know Mr. Carney pretty well over the last couple months I've been on this case. I think he's a polite man. I think he's an affable man. I think that he's in a situation where I know this court's well aware of the circumstances surrounding, the Department of Rehabilitation and Corrections. Obviously, we think he made some bad choices here, right? I think that he sought to, alleviate his circumstances as it was. But I do know that he has, I know the court's aware, he's been transferred to Lucasville. It's a much higher security level. I know that is not enjoyable for him. I think he's already faced some consequences. I would ask this court to issue an appropriate sentence on the lower end, as I think it's notable. Obviously, none of the contraband was ever actually possessed by Mr. Carney.
Mr. Carney, is there anything you'd like to say before I sentence you?
I just apologize. There's nothing I can say. But apologize to the court. I had nothing to do with it. I still remain innocent, but
I'm sorry,
I still remain innocent to where
I had
do
nothing,
it, but
nothing to do with it.
There's nothing I can do about it. I can just apologize to the court. That's all.
The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. There are two offenses here. The court does find that they are offenses of dissimilar import and do not merge for the purposes of sentencing. Anything on that?
No, the state would agree.
Your Honor, I would ask for them to merge, but I do believe that under Ohio law that they would not automatically merge.
All right, on count one, then, the court will order you to serve a minimum term Well, before I get to that, Mr. Carney, first off, shame on you. Just absolutely shame on you for dragging your young daughter, who you profess to love, into this. I quite frankly agree with the jury's verdict. I don't often do this. This is probably the second time in 10 years that I've actually sentenced a defendant in front of a jury, and I'm doing it for a reason. Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. Luckily for you, I think that the state, and I think we're going to do it on Thursday, her trial was set for Thursday, as you probably know. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that, who has your grandchild at home? 4 months old, 5 months old? Why would you do that? And that's a rhetorical question, Mr. Carney, because quite frankly, I'm not looking for a response at this, but I'm just scolding you because I think it's shameful for a parent to drag, and we see these cases all the time where they talk these young women, but to talk your own daughter into doing something like this is just absolutely disgraceful, in my opinion. Your record dates back to 2001, your criminal record. So you have a criminal history of over 25 years. This is your third conviction for aggravated trafficking. 3. You're not learning anything. So, The court is going to order you to serve a minimum prison sentence of 5 years, a maximum prison sentence of 7.5 years. That has to do with Reagan Tokes, as you probably are aware. And on count 2, the court's going to order you to serve 36 months. That to be served concurrent with count 1, but consecutive sentence to your current sentence. So I'm adding on 5 to 7.5 years to your current sentence. The court does find that a consecutive sentence is necessary to punish you and to protect the public from you. It is not disproportionate to the conduct or the danger that you pose to society, and this offense was committed while you were already incarcerated in the Department of Corrections. You have 0 days jail time credit. You are subject to a mandatory period of post-release control on this, as you probably already are on your other one, which means that when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. If you violate that supervision, you can be returned to prison by the Adult Parole Authority for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time will run consecutive to any additional prison time that you receive. You have 0 days jail time credit on this 5 to 7.5. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Because this is a mandatory prison sentence, you are not eligible for early release. You're not eligible for the good time credit of 5 to 15% against your Reagan Tokes time. Regardless of that, the Department of Corrections, when you finish your minimum term of 5 years, the Department of Corrections, unless they determine that you will be released when you complete your minimum term, unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. Has the Department of Corrections added any Reagan Tokes time onto your current sentence? Not yet?
No.
All right. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release, and that process could repeat until you are released. You do have a right to appeal the jury's verdict and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Pickles.
Nothing further, thank you, Your Honor.
Mr. Brunner.
Not this time.
All right, that's all. Thank you. All right, ladies and gentlemen, at this time, we are obviously finished, and I oftentimes don't ever do that. I've done it one other time that I can think of. I will explain that to you in the back. But you are released from all of the restrictions that I placed on you during the course of this trial. So I'm going to send you back to the jury room right now for just a brief time. Justin will return all of your electronic devices to you, and I'll be back personally to thank you for your service. The attorneys may want to talk to you if you'd like. If you don't, that's okay too. So this time I'm going to excuse you back to the jury room. All right.
I think they usually do on Thursdays, but I'll ask the judge, okay?
How long it take for the appeal to come in?
Well, I mean, so I'm gonna file it. It'll, like we talked about, it'll probably take a couple weeks to a month.
It's gonna appeal.
To get the transcript ready. And then from there, your appellate counsel will have, 4 to 6 weeks to file their brief. Okay? Oh, that's for what? I'll file that.
Are you able to take us off the record?
All right, sir.
So I just can't,
Yeah, he's going to appeal. Which will take a couple months. Good luck with that. The judge says, only the second time in my career that I can remember I've sentenced a defendant in front of the jury, because I think you need to see this. Jury, you got it right. Wow, that is some strong words. So, looking here at a Court TV post on Twitter. A Georgia prosecutor, they say, this linking back to their argument, a Georgia prosecutor has offered a formal apology after she says she used AI when she submitted briefs to the court that cited cases that don't exist. Wow. The errors were not intentional, she said on Friday. She used traditional and AI research tools, which she prepared. She intended to provide a more detailed explanation of the relevant legal principles. She made stuff up. But she didn't verify the case references. Wow, I hope, honestly, I think she might need to get a new profession. That's pretty extreme, but she might need to get a new profession. That's, and not just for the AI, honestly, not just the AI. I think her argument that she made on its own, without the AI case references, would be a sign that she's probably in the wrong profession, where she says there was no evidence to support, and she listed what it was, when there actually was testimony in court given to support it, direct testimony to support this specific area that they were arguing over. But she's like, yeah, but that came from Hannah. That came from the defendant. So there's no testimony. That is not how it works. If you don't understand the basics of how the court system operates and what testimony is and what it isn't, yeah, that was the Hannah Payne trial, also in Georgia, which is why we're banned from Georgia. We just can't go down there because bad things happen there. All right, looks like they're wrapping up there in Georgia. Let's see if there's anybody else that we need to see. I think Judge Boyd is still working her magic.
Is there anything else you need?
Not this time, Judge, no.
All right, thank you.
Thank you. May I be excused, Judge?
Yes.
Thank you. Thank you.
Yes.
Is there a court case starting this afternoon?
Yes.
Mr. Moore, the eval has been started. They said they'll have a result for us by the end of April for the veterans treatment. That's what we had pre-said. I had your probation officer call this morning.
All right. Ms. Ferguson. Yeah. I need a date in May on Troy Moore. All right. Oh, here. Perfect. Oh, you're more than welcome to have that.
Cool, thank you. Yeah, you know, I'm in the Esperanza.
Yeah.
So yeah, I good. Thank you.
You're welcome.
Okay, May the what? 8th? Yeah, got it. I'll make them sign. Thank you so much.
You're welcome.
The Georgia hearing for where they made up the AI references was in front of the Supreme Court, the Georgia Supreme Court. It doesn't get any higher than that in Georgia. Not the place you want to try out your AI skills.
All right, anyone ready over there?
Yes, if you've got plea paperwork and bear with me. All right, get it done.
Warren had a verdict, yes, just a few minutes ago. You can go back and watch it, and it was a good one.
And Norma, where's Roger Perez?
What to do?
I'm testing
and
out
Valentina Kogut.
some of the foods. These spicy dill pickle balls are also good.
And is paperwork done with Dotson? Oh, you're going over paperwork. Okay.
Just watching to see if Judge Boyd's going to call a defense or call a court case, or if we're just doing the regular docket stuff. Is that a jacket that woman's wearing, or is that the dress with all the tassels? That is some dress.
Well, it looks as though we will not be having a jury trial today.
Oh, yeah? Why is that?
We get people working things out. You know, it reminds me of the old song, "We Can Work It Out."
So the judge breaks us the heartbreaking news. No jury trial today for her. Somebody's taking a plea deal. Let's see. Judge McBurney is still working. Thurston County. Let's see. See if we can go to Kansas or something. What's this one? Haven't been here very often.
Standing as well.
Okay, thank you. Ms. Marchetti, it's my understanding today that you wish to enter a guilty plea to what is subcase A, that being operating a vehicle under the influence of violation of section 4511.19A1A of the Ohio Revised Code. In exchange for that guilty plea, the 2 remaining charges would be dismissed at your cost. Is that what you would like to see happen today?
Yes.
You understand by pleading guilty to this charge that you're waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading guilty to this one charge. Is that what you wish to do?
Yes.
You are represented by Ms. Wilmer. Have you had sufficient time to consult with her, and are you satisfied with her counsel?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No.
Are you currently on probation,
Okay, we're gonna jump again.
community control, or post-release control with any court?
Let's jump here.
No.
Oh, that's the wrong one. How about
Having a hearing. All right, I'm going to begin with cause ending in 0383, which is Bridge Over Troubled Water LLC versus Caitlin M. Leonard. And looks like Miss Leonard here, and I believe someone for Bridge Over Troubled Water is also here. Okay, if you can go ahead and unmute yourself. And
Yes, sir.
Ms. Coggin, are you here as the employee of the landlord and agent or counsel?
Yes, sir. No, as an employee of the landlord.
Okay, all right. Have you had an opportunity to speak with Ms. Leonard about this case to see if perhaps you can reach some type of an agreement before we move forward?
We did. We actually reset this case. So we were on docket for last Tuesday. This is actually the reset portion. And at this time,
Looks like we need to go forward, right?
4 months. Yes, sir. We're owed 4 months worth of rent. And we haven't received any payment or keys.
Okay. Well, we'll get into those
So
details.
sorry, do I have a moment?
Go ahead.
I did pay a portion last week. I'm in
Okay.
between jobs and I've been dealing with some major medical stuff with my family.
We'll get into those issues in just okay.
But I did, the movers are like the key, we discussed turning in the keys by the 1st. I
Okay,
already
well-
have the storage unit, everything's been moved. I'm heading back over to the house to get the
Ms.
final
Leonard,
pieces
Ms.
today.
Leonard, we're going to get into the case.
Got it.
And you can talk about that. Okay, so I need to swear you both in first. And Ms. Coggin, if you can please go ahead and unmute yourself. If I have you both raise your right hand, please. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
All right, Ms. Coggin, this is your case. You may proceed, please.
Sure. So at this time, we are requesting possession of the unit. We are owed base rent $7,800. That would be the months of December, January, February, and now March. We have we
What
gave
monthly rent?
It was the prosecutors. in her case.
1,950.
And you said this goes back to what date?
December.
December.
No payments have been made since December.
There was a portion paid last week.
So hold on, Ms. Leonard, hold on. You'll have an opportunity. All right, so if I do the 4 months times 4, that comes out to
Yes, sir.
1,000. Sorry, I
1950?
my apologies. Let me do it again. All right, 1,700. You're correct. All right.
Yes, sir.
All right. So 1950 monthly rent, 7,800 past due rent prorated through today, which today's last day of the month. So, all right.
Yes, sir.
Go ahead. Tell me about the notice.
Notice to vacate was sent on February the 3rd. Miss Caitlin, she did mention to me that she had gotten a new job and that she intended to make some payments. However, we held off on filing until March the 4th was when our filing was made.
Let's go back to the notice. So you sent it on February 3rd. How many days notice did you give her?
I actually gave her. I'm sorry. So the notice that I sent gave her until the 8th. So I gave her 5 days.
Or give her 5-day notice. And what day did you file this eviction?
The court on March the 4th.
Okay. All right. Anything else?
No, not at this time.
All right, Miss Leonard, you said that you made some payments. What payments did you make? And do you have some evidence of that?
Yeah, so I paid Lindsay last week. I asked for an extension. It has been a very, also my place I have not been able to live at my place due to a leak and mold. I do want to add that, and I have not been at my residence.
Let's take this one thing at a time.
Okay.
You said you made a payment. What payment did you make?
I paid $1,000 last week. I asked for a little bit more time. Again, this market has been awful. The meta job fell through. I have another final interview tomorrow with a role. I will be back on my feet very quickly. I'm sorry.
Hold off just a moment, okay? I know there's other information you want to tell me, okay? But let's stick to the questions, and then I'll ask you if you have other things to add, okay?
Got it.
You said you made $1,000 payment. How did you make that payment?
I paid it last week through the app website that the landlord uses hasn't been working. It was shut down. So I asked Lindsay, yes, on the portal, because I needed a little bit more extension.
Hold on. Just answer the question only, okay? All right, we'll get through this a lot quicker. So you made $1,000 payment on the portal.
Yes.
Okay. Do you remember what day that was?
It was last Tuesday.
Okay, Miss Goggin, can you look up on the portal to see if there was a payment made on Tuesday?
I'm actually looking at the ledger right now. There's no payment reflected.
Okay.
No, I paid $1,000.
Miss Leonard, do you have some record
Yes.
from your bank showing that the payment was actually withdrawn?
I paid it, Lindsay, because the court did the extension due to the payment. I was able to get a brief loan.
So I actually asked for the extension before the payment reflected as a courtesy because she's been there for a long time. And there's no payment on her account.
So Miss Leonard, I need to see some evidence that the payment actually in fact went through.
Okay, let me see. I get a receipt. Logging into the account. I can forward an email to, let me see. Is there something that would cause it not to draft? I'm showing it's still in the Venmo that I sent, but I have a receipt that I paid. I was not aware of this at all. You
have not received notification that you paid?
No, I received when I issued the payment. Let me go to my email it's linked to my account. I had confirmation that I paid the landlord. I'm seeing it in my Venmo account right now. But last week when this happened, I had confirmation of the receipt.
As far as I'm aware, I don't know that it accepts Venmo. I've only ever seen credit card or
Miss Leonard, Miss Goggin. Okay.
It let me do Apple Pay.
Oh, Miss Leonard, please stop.
Sorry.
You cannot speak while other people are speaking, okay?
Apologies.
I promise you, you're going to have ample opportunity to say what you need to say, okay? But let's keep this brief. Let's keep it to the questions that are asked, okay? Now,
Yes,
Ms.
sir.
Goggin made a comment that the portal does not accept payments from Venmo. So if you have some record that you made a payment and it cleared your bank, I need to see that. If you do not have it, then that's fine. I just need to know if you have that or not.
I have it. I'm pulling it up right now. So it's through Apple Pay, which I have a Venmo debit card linked to my Apple Pay. And it let me pull that up for you.
You should be able to share your screen. Stephanie, make sure that she has access to share
I
her
don't think you
screen.
can do it on your phone like that.
Let me see. I'm searching in my email right now.
Maybe. We might have to go widescreen on this one.
You have the exact date of last Tuesday. That was the 24th.
Yes, it's like 24th.
Perfect.
Okay, I'm not saying she's lying, but Miss Leonard currently owes $17,000 in rent, which is pretty much over a year. Like a year's worth of rent. For the last year, she has not been paying.
Okay, it did not clear.
That's all we need to know.
Okay.
I was under me and Stephanie had, or Lindsay, I'm sorry, had discussed if I paid, it was fine and I could get a brief extension, which I thought it was. I have the funds right here. It's all saved. Let me try to do another one right now.
Miss Leonard, don't send the money right now.
Oh, okay.
Okay, so if you put your camera back on, please.
I think the $7,800 was previous.
And I have a confirmation that I did issue the payment. I have that confirmation though.
So you have confirmation that you sent the payment, but there's not confirmation that it actually cleared and was
It
paid.
didn't clear.
Okay, so that means that it did not get paid because you still have it in your account. So I can't give you credit for that. Now, let me ask you, are there any other credits besides that you believe you're entitled to that you did not receive?
I have had a really bad, so I transferred units. I guess no, sorry.
Okay. And I'll just let you know, because in case you, since you brought attention to the fact that you had either water issues, you've had problems. This is an eviction case. And in these eviction cases, it's very narrow and tailored as to what issues you can raise in this court. As a general rule, there's two basic things that I'm looking for. There are other little things, but the two key items that I'm looking at here, number one is the notice proper. Okay. We have to make sure that that's done, and it appears that everything's proper and there's no claim here that there wasn't a proper notice. So number two is payment being made. Absent that, there are no defenses that you can raise on an eviction case. Okay. In other words, you have to have paid the rent, or you have to have paid an amount in order to get credit so that the judgment is less. There are no counterclaims allowed in this court. So for instance, if something's not working, let's say it was the water, or let's say it's the plumbing, let's say there's no air conditioning in the middle of the summer, no heat in the middle of the winter, all of those things, you would have to file it under a repair and remedy claim. Okay. And in a repair and remedy claim, you can file that, but in order to be successful, you have to have been paid up in your rent, and you have to go through certain procedures of notice for them to fix it, and they refuse to fix it, those type of things. None of that is relevant here in this case. Okay. So that's why I'm asking the questions about payment and about credits and about notice. Okay. Is there anything else that you wish to add in your defense in the case?
I would like to add that I have a few pieces left at the house. I just came back up from Houston. I'm getting the final pieces out. Movers, all that's been arranged. I haven't even been living at the place because I'm unable to live there due to everything. I also am, I would prefer to say 6 weeks, but within 4 weeks, I can have the full balance paid, hoping within the next 2. But again, I don't want to say that just because I don't have my official start date. We're talking about the final details of my offer tomorrow. My call's at 3 p.m. tomorrow to finalize the details. So I'm hoping to pay everything by the end of the month.
I will explain to you what your options are on what we can do, okay, here in a moment. In the meantime, I find that the monthly rent is $1,950, that the past due rent prorated through today is $7,800. That'll be the judgment of the court.
Okay, I was wrong.
You may appeal my decision, and you have 5 days to file that appeal. And your appeal bond will be set at $3,900. Now, there are 3 different ways that you can post bond for the appeal. And the first way is in cash. If you had the cash, you probably wouldn't be in this situation. So that may not be an option for you. The second way is you can go through a bonding company. Civil bonds are a little bit different than criminal bonds, but you would have to talk to them. There's a cost associated with it. And again, a lot of times that is not an option that's feasible for people. The third option is you can file an affidavit of inability to pay. The court here has those forms. You can get them online, you request them online, or you can come here in person. The court, meaning the staff, cannot assist you in filling that out, but they can certainly give you the form and you can fill it out on your own. Again, you have 5 days. Bear in mind that 5 days from today is a weekend day. So you'll get the next work day in order to do that. All right. So you can file it by the next work day. If you do not file it, then the apartment complex on the following day after Monday, a week from today, they can then file the writ of possession, which means that it'll come to the court, the judge, myself, or Judge Holmes would sign it. We then send that to the constable's office. They take a group of people to your apartment and remove anything that's in there. You've already indicated that you have pretty much everything out. Okay. But that's basically what they would do. Now, if you still have items in there, you're responsible for securing those items once they put it on the street. Now, if you've moved out completely and you turn in the key, you can always do that, right? But because we're having this hearing here today and right now, and the key has not been turned in and you have not turned over possession, then that's why we're still going forward, okay? The other option is try to work out something with the apartment complex on how to pay that balance. Well, clearly you've already decided that you're leaving. There will be a judgment against you. Now, once you pay the judgment, then at that point, they would then release that judgment, okay, after the fact. So that is, in essence, the procedure. If you have any questions, there's paperwork again here at the court that will outline some of these things that I just told you. Do you have any other questions, Ms. Leonard?
No, sir.
Okay, thank you. Good luck to you, ma'am.
Thank you.
All right.
All right. Next case on the docket is cause ending in 0426.
This is Bridge
And
over,
this is
over
Bob Bowden
troubled
versus
waters.
Miguel Dubose. Just a second here.
Yeah. When you get behind, they make it more difficult
Okay.
to.
All right. Mr. Bowden. And how about Mr. Dubose?
Shelly, thank you very much.
Mr. Dubose.
We're in
is
Texas
not
right here.
Okay.
Travis County.
All right, Mr. Bowden, is it Bowden or Bowden?
Thanks for asking, Bowden.
Bowden, okay.
He's very pleasant.
It was obvious to me and I said it wrong anyways. So, all right. Okay, sir. So Mr. Dubose is not here. I'll let you go ahead and proceed.
Well, I'm being represented by Mr. Bowles here, but it's simply a case of a tenant who's not paid his
Hold on
rent.
there. Mr. Bowles, are you an agent or counsel?
Agent.
Okay. We can let Mr. Bowles go ahead and proceed. And if he needs to call you to testify, then we can do that. Okay. All right.
Okay.
Mr. Bowles, you may proceed.
All right. This is a non-payment of rent case. The rent is $1,850 per month. The rent that was not paid was $1,850 for February and $1,850 for March, which comes to a total of $3,700. The notice was sent on March 3rd by USPS, and the case was filed on the 11th. We have not heard from the tenant in any way, shape, or form for at least 4, 5, 6 weeks. It's been a long time. And that's our case.
And they have not submitted the keys or anything to you or anything like that?
No, Your Honor.
Okay. All right. Then I find that Mr. DuBose failed to appear today, even though notice to do so, that his monthly rent is $1,850, that the past due rent prorated through today is $3,700, and the appeal bond will be set at $3,700. All right. Thank you both. You're free to go. Have a good day.
Thank you.
That was quick.
Next case on the docket, cause ending in 0410. This is Mid-America Apartments versus, LP doing business as MAA South Lamar versus Matthew Merzicki and all of the occupants. And is it Tiana Amerson?
Yes, sir, that's correct. Yes, for MA South Lamar.
All right. Well, I do like your name, Tiana. That is my daughter's name.
So you win automatically.
That at least is a good thing for today.
You have the right name.
Good to hear.
All right. So let's see here. Well, I'm guessing that you're much younger than my daughter, so it was not a popular name back when I did it. And I say I did, I had nothing to do with it. My wife was smarter than me.
Oh.
All right, sorry about that. Anyway,
Okay. So this case is in regards to non-payment of rent for March, for imposition of the unit. Sorry, I lost my train of thought. The base rent is $1,555. The notice was delivered directly to the resident on March 5th, and I had filed on March 9th, and I haven't heard from the resident or received any kind of payment.
And how many days notice was the?
It was a 1-day notice since it was delivered directly to the resident.
All right, 1-day notice. All right. So how many months did you say non-payment of rent?
For March.
Just for March?
Yes, sir.
So the past due rent is the $1,555, is that correct?
That is correct, yes, sir.
All right. I find then that the defendant failed to appear today, even though notice to do so, that the monthly rent is $1,555, that the past due rent prorated through today is also $1,555, and the appeal bond will be set at $3,100.
Okay.
All right. Thank you very much.
Thank you. Appreciate it.
You're welcome.
All right. Let's see if we've got
Next
anything
case
else.
on
the docket, cause ending in 0407. And nobody appeared on this one, you said?
No, Judge.
So this will be a DWAP then. This is default judgment, and plaintiff. All right.
DWAP. Looking to see if we've got anything else. Not a lot of people live right now. Why is that? Maybe it's only 3:30. Hear another chainsaw outside. Judge Simmons, no. Nope. We're striking out on all fronts. Just got here. How rude court is. How are you guys doing? Emily D. Baker is interviewing the private investigator from Corey Richards. That's awesome. That's really cool. Spring break, maybe. Hey, look who's here. Good news. You were right. The door does need new paint and not just a good cleaning. I think she's. Why did we go there? Why was that on? Why do we have a logo on the middle of the screen? Anybody? How did I get the logo off my screen? Somebody needs to tell me. Hang on one second. Let me look at the switcher. Look at the lights. Oh, everything's on. That's me. I need me. That off, that off, that off. There we go. Let's turn that back on. Okay, fixed it. I think I bumped something. Yes, I've been painting. Painted in the kitchen. Apparently, after 3 years of owning a completely remodeled kitchen, it's the right time. The wood has settled. It's expanded and contracted, and whatever it does, it's rested at an appropriate time. So I painted it because it was bare wood. So did paint all the bare wood in the kitchen from the remodel 3 years late. But I need to do a little bit more on the door to the pantry, and apparently also on the bathroom door. Because Mrs. R.A. is cleaning things. 3 and 7. What's 4 years between friends? So, how are new parents and baby doing? Very well, although tired. They're surprised that the baby's not sleeping through the night. I'm not taking any glee at that. No, I'm not getting any joy knowing that that they are experiencing what we experienced. A little bit, just a tiny bit. But I do hope that the baby rests and they rest, so it's all good. Mathis, I'm seeing your chats. What? At least I saw this one. You suggested something else earlier. A Texas hearing, right? Which Texas hearing? Is it live? We tend to like the live ones, but got a great case on appeal for us to watch. Which one is it? Maybe you just tell me in chat and I might be able to pull it up. Assuming we're talking YouTube, right? No joy to be found. Zero fun, sir. Zero fun, sir. Still waiting for my bathroom remodel to be completed. We started in July of 2019. See, Jen? What's a year? A year is pretty good. I did 2 back-to-back bathroom remodels. I think each of them took about a year. Well, I guess the one isn't done because I still need to paint, but drippy tapping on my bathtub, don't know how to solve. Probably needs new washers in the faucet, in the on and off. Hey, Mrs. R.A., how are you doing?
Hey, I'm going to do like a couple counsel thing because you're not watching court and we can do this.
Okay, marriage counseling takes place right here, guys. It's free. Today only you get to watch.
I called the shop and they're going to get the car in a little bit next week. But she was funny because I was calling from my cell phone, which she's never seen before. She doesn't know who I am.
Who dis?
Yeah, she was polite. And so she was like...
She said, oh, it's you.
Yeah, pretty much. She was like, okay, what's your name? I was like, Jennifer. She said, what's your last name? And I told her, she goes, oh, hi. I was like, it's too late, girl. You got me on your list. I'm showing up on Monday.
That's funny. Okay, car's going in for a tune-up.
Car's going in for a tune-up. Your phone case is just going to be broken now. Welcome to, all of our iPads are broken. It's an Apple feature.
No. Look, I think I can fix this one.
Oh, how?
Because
is it just the cover that's broken?
It might just be the cover. Here, let me.
Somebody dropped our iPad the other day and broke it. That's a bummer.
Let's see. Watch carefully here. Ta-da!
Is that it?
It was just broken in the corner there.
That's why people use those.
Yep. Now I can't use my phone.
It's got like new car clean.
I've got like
Don't touch
Cheetos
it.
fingers. These little protective things, they're absolutely amazing.
Yeah.
Because you can like crack them and then glass shatters. But
yeah,
it's the second one that's broken, but protected my phone.
Okay, but I'm not done.
What?
We are also going to be taking cookies to our friends who are moving on Tuesday.
Yes.
Or on the 2nd. And so
I asked what kind of cookies. This is important for me because I know you make more than just the deliverables. There's usually spillage that occurs.
This is a skill I didn't used to. I used to be like, we're making what we're sending. And then I discovered that if you do that, you have to send like the burnt ones and the ones that aren't quite done right. So now there is some spillage.
Yeah, like triple the batch.
I quadrupled it.
So you know that one of them is going to be good.
Yeah, it's good. And there's somebody else that we're taking to as well. So I'm just saying.
Hang on. I'm going to just Google iPhone 16 Pro Max.
Okay. All right. He's not listening. You guys listen.
Okay.
As soon as you're done here, we're going to hop in the car and go deliver those tonight because I don't have anything else on the schedule for us tonight. Do you?
What day is it?
Tuesday.
Tuesday, no.
I mean, we planned already, but
I know, but I didn't listen.
Pay attention. I know. This is a thing. Okay. So that's the car, the phone, the cookies.
Protect.
Oh, the bathroom door. Okay. So I thought that, I thought I could fix it. Yeah. As I'm scrubbing, I'm like, that's not a thing that needs to be fixed. Like, as I scrub, the paint just like flakes off. I'm like, oh, it was a hole. Okay. So that
might need a new door.
Yeah, that's not as good.
It's the original 1915 door.
It's really old.
Back when that was a closet before they made it into a bathroom.
Yeah. So. Do you think that's what that was originally? The door is so narrow.
Well, they built the house before there was plumbing.
Yeah. Yeah, maybe it was the outhouse. Too close.
No, the house would have been.
Yeah.
We built.
So the door to this bathroom is so narrow that you almost have to turn sideways. And when we bought the house, before we remodeled the bathroom, the only place for the sink was in the doorway, like literally. So the distance from the wall on your right, you're opening the door, the wall is pretty much right on your right-hand side, and the sink is sitting on that wall. So you have to like think skinny thoughts and sort of tuck yourself up and around this sink. And that didn't work. So we got rid of that sink. We put a tiny little sink in, and Scott was like, I hate the tiny sink. I don't want to do this.
Okay, hang on. By tiny sink, you couldn't, with my big head, okay, 'cause measure like from top to here. If I were to like brush my teeth and then like want to spit the toothpaste bubbles out,
the tooth bubbles.
You lean forward till your head is like horizontal and your head like hits the wall. And then you spit, and it misses the sink because the sink came to here. You're trying to like spit towards the wall.
There's some skill involved. It took a little bit of effort.
It was terrible. It was terrible.
So then when we completely remodeled all of that, we put an actual sink on the left-hand side where the shower used to be. Now there's room for a sink. So why am I telling you this?
I don't know. I know that part.
There was some point. Because the door is so tiny.
I need to paint.
So
you do have to turn sideways to go in the bathroom.
You cannot replace this door. They don't make doors this size anymore. We have to find a way to clean it, paint it, prop it up. It just must work as it is. So that's
So
what's
now I
happening
get to
with that.
paint it.
Yeah.
It's already it has a special bow to it. There's only doors that old can. And so the door closes and it still has about half an inch before like the latch engages. So you take your left foot and you put it up next to the door, not by the door handle, up against the wall, and you grab with both hands on the doorknob and you just lean back and it will pull the door in and close it properly, which is fine. Then the bathroom door is closed. You can do all your business in private. But then when it's time to come out, the pressure on that latch, on that door, is so extreme that you're like vice gripping that door handle, but just put everything in it to try to twist it because it just slips in your hands. And if your hand's wet, you're not getting out. You have to dry your hands before you can get out of the bathroom. You've got to like clamp down on that thing and just like twist and try to wiggle it until it can free it. And once it's freed, that door just like boom, just flies open. It's like
if anybody's walking in the hallway outside,
bam.
This is how we say I love you. Whack.
It's like opening the door, clear, and then you like work on it, and everyone just stands back. So
yeah, it's fun.
Wait, let me tell you about my house. It's beautiful. You guys would love it.
Remember in the beginning when we started 110 years ago?
All you guys hear from us is our complaints. But I tell you,
old.
It's a gorgeous house. People see pictures of it and they're like,
in front of the
"This is the
Walmart."
house you whine about."
They're like, it's beautiful. I love that house. Every time we drive by, we take pictures. I'm like,
stop that.
You want to trade? Anyway. Yes. So I guess this is a great topic for maybe the podcast.
Yes.
Coming up.
It doesn't belong here. Do you have something else you want to do?
No,
Maybe a court case? What do you think?
I think we're done. Our court case today bailed on us.
Oh.
They took a plea deal without permission. At
What?
least without our permission.
Rude.
I know.
They made decisions for their own personal benefit. Have you said thank you yet?
Yes.
Okay, awesome.
Oh my goodness.
Because wow,
yes,
that's amazing.
Thank you to just absolutely amazing. And I hope you were all here for it, so you didn't miss
I don't
it. Because we have both. We have Bug, Melissa, and Nosy Rosie that work together. If you missed this, on making the most amazing gift.
It is gorgeous, and besides that, I love the idea of people just being friends. That's awesome. And how cute is that, you guys? How cute is that?
This is a gigantic diamond painting. It's huge. It's like 24 and a half by 17 or something like that. It's just huge. By my math, 42,000.
By your math? You mean you Googled it?
42,000. My math is Google.
Oh, okay. Sorry.
I used AI. I did the measurements myself.
Oh, good.
And then I had to figure out the dots per inch, which I figured about like 2.4, 2.6, 2.8. It's around there, depending on the size. Anyway, this is incredible. It is beautiful. We're going to send it on. We're going to repackage it, send it back on to my son.
Yes. Yep, I'm grandchild. That's beautiful. Awesome, beautiful, amazing. Got a jaw drop the moment that we opened it and read the card. I was like, what is happening? Why are the people around us so amazing?
I know. It's so cool.
Just, wow. Yeah.
Yeah, but the story behind that, these three wonderful people who we named off, Nosy, Bug, and Melissa, got together and decided to do this. They all had this love for diamond painting in common, and it started at one house where a part of it was completed. They then mailed it to the next person where next part was completed, and then mailed it to the next person where the rest was completed, and it was framed and then sent on. So all three of them worked and put countless hours into this.
So many. I've done diamond painting, and I'm like, wow, that's requires too much effort.
It's perfect. It's like immaculate,
gorgeous.
amazing.
I love the colors. So perfect. Love it.
Mrs. Ari's voice is coming to us from the skeleton. She's over there.
I'm the soul of the skeleton. I'm the skeleton's conscience. He didn't listen.
Yeah. I could move the camera, but then you'd see the bookshelf. You don't want to see the bookshelf.
No, you do not.
But Bug Duggar, thank you, and to everybody involved.
Yeah.
Thank you very much.
100%.
That meant so much. It made my eyes get really sweaty just reading the card.
All the kids were like, what?
Yeah.
So why are people so nice? I'm like, I don't know. They're pretty amazing.
It's called Round Robin in the craft world.
Oh, that's cool.
It was amazing.
Okay. I love all of you. I got to go.
Love you. I love you more.
Okay, bye.
I'll see you. Bye. Don't take the mic. Okay. All right. All right. We are, I think we might be done. Wait, Mathis, I'm sorry. You're trying to get me. Mathis has been trying to get my attention. He says, look up this. Test the video is whatever this is. So if I just like Google that, is that what you're saying? Or go to YouTube? I'm going to paste that one and search. It pulls up Catnut Williams from 3 months ago. I can't use her feed. I've got a Hook Global, can't use them. Undivided with Brandy Cruz, can't use them. Live court officer ambush shooting trial yeah, it's not pulling it up. Where am I supposed to be looking? It's the part in the URL. Oh, what's the other part? Okay, we're working on this. It's the 14th Court of Appeals. Okay, now we're getting somewhere. 14th Court of Appeals.
Remember in the beginning when we started 110 years ago?
What's the date of the argument? The 12th of September, so it's an old one. Mathis, all this work and it might be politics. September is month number 9 when I just counted on my fingers. So month 9 on the 12th. Would have been alive. Definitely not politics. December 9th. Okay, that's different. 12/9. I'm getting there. 12/18, 16, 12/9. Two cases were heard that day. Is it? I'm guessing it's not the 54-second one. Okay. Hang on. We're trying to watch this video from Mathis. Okay, let me MFPQ. That's okay. I found it. So now let's watch. Let me bring this up on the screen. We'll see if we can take a gander.
Remember in the beginning when we started 110 years ago?
Mathis has some good trial suggestions to watch as well. Sometimes his stuff gets really heavy in the technical weeds, which is a little much for us, but we'll check and see what we've got. Does this look right, Mathis? A, make me bigger. Now we're going to skip ahead until they start, which apparently is not yet. Here we go. Looking for audio. Just 1 second here. We're going to put it to Black Magic. Or, oh man, where is it? To the Roadcaster. I'm going to put it to the Roadcaster. Just 1 second.
We're ready when you are.
All right. Here's your timer. Starts when you open your mouth.
May it please the court. This appeal concerns a failed attempt to invoke the TTCA's immunity waiver based on the plaintiff's failure to overcome the evidentiary burden to demonstrate proximate cause, an element of the TTCA's immunity waiver related to the use of automobiles in personal injury cases. In this case, the trial court should have granted the City of Houston's traditional motion for summary judgment because the City of Houston successfully challenged
34 minutes.
and negated jurisdictional facts concerning the crucial element of proximate cause. The appellate.
We're going to fast forward. It's not this one. As interesting as the automobiles in the City of Houston is, 34 minutes is not the start. Stomp, stomp, stomp.
All right, we're here on Aguirre versus the State of Texas. Would the appellant like to save time for rebuttal?
Sure.
Yes, Your Honor, I'm going to say 5 minutes for rebuttal. And my name is Doug Ladd, and I represent the appellant, Eric Aguirre.
So he gets 5 minutes to start.
We are ready for your argument when you are.
Very good.
Change the timer to 5, please. Or just show 10 and show 5 when you're stop at 5.
May it please the court. I took the bus down here from Dallas this morning. If the bus had gotten me 60% of the way to Houston, I'd be giving this oral argument from the Madisonville Buc-ee's. If the bus driver had told me he was 60% sure he could get me to Houston safely, I wouldn't have gotten on the bus. I use that example because these are the two ways that we can use percentages when we're talking about the burden of proof in a criminal case. We can talk about the quantity of proof. How far did the state's evidence go? Or we can talk about the quality of persuasion, the level of certainty. How sure are you that the defendant is guilty? So when a judge tells the jury in a criminal case that beyond a reasonable doubt can be as low as 60%, it can mean one of two things. Neither is good. It can mean you can convict if the state got 60% of the way there. Or it can mean you can convict if you're 60% sure the defendant is guilty. Due process requires more than that. The reason due process requires proof beyond a reasonable doubt in the first place is because, as the Supreme Court told us in Jackson versus Virginia, that standard impresses upon the jury the need to reach a subjective state of near certitude as to the guilt of the accused. And so, as the court later said in Victor versus Nebraska, due process not only requires the state to prove guilt beyond a reasonable doubt, It requires the trial court to avoid defining reasonable doubt so as to lead the jury to convict on a lesser showing than due process requires. It's that duty that Victor versus Nebraska places on the trial court that settles the preservation issue in this case. Because the Court of Criminal Appeals made clear in Proenza v. State that when a law, here due process, imposes a sua sponte duty on the trial court to refrain from acting, in this case, to not define beyond a reasonable doubt in a way that lowers the burden of proof, that creates a right that is waivable only. It's not subject to forfeiture by inaction.
Counsel, does that mean that you're conceding this falls under the second category, Marin?
Pardon, Justice?
Does this mean that you're conceding that this kind of alleged error falls under category 2 in Marin?
Absolutely, Justice Bridges. This issue is a Marin category 2 right. That's what I'm advocating for. I think that's the flaw in the state's argument. The state is arguing only preservation, and it's saying that an objection was required in this case because it's saying that the trial court's comment wasn't fundamental error. And by that, it means the comment didn't taint the presumption of innocence. But that's the type of harm-based preservation, the harm-based fundamental error analysis that the Court of Criminal Appeals told us in Proenza not to use. The preservation question under Marin doesn't look at whether there was error, and it doesn't look at whether there was harm. The preservation question under Marin only looks at the nature of the right that was allegedly infringed.
But you still have to show harm.
No, Chief Justice Christopher, you don't have to show harm. And
I thought that was only in a category 1.
No. That's what the Court of Criminal Appeals said you can't do. In Proenza, harm has to be kept separate and distinct from preservation.
No, I understand that. Okay. Assume with me that we conclude that it's a category 2, it didn't have to be objected to. It's error. There still has to be harm. Therefore, it's reversible.
No, Chief Justice Christopher, there does not have to be harm because the Supreme Court told us in Sullivan versus Louisiana that this type of error, it doesn't have to be preserved. The court finds error. You get to the question of harm. You cannot do a harm analysis for this type of error, and so it's what the Supreme Court called structural error. That it would actually be illogical to try to do a harmless error analysis under 44.2a or 44.2b. What the Supreme Court...
Well, I understand it's not under 44, but is there a constitutional harm? There still is a harm analysis.
Well, so constitutional harm, 44.2a is modeled after Chapman versus California. And what Sullivan says is that when you're talking about the trial court defining reasonable doubt in a way that lowers the burden of proof, you now have a jury that is rendering a verdict having been told the wrong standard of proof. And what the court said in Sullivan is the evidence could be overwhelming. But the fact that the jury was given the incorrect definition means that jury did not render a verdict within the meaning of the Sixth Amendment. And harm, the question of harm looks at what impact did this error have on the verdict. If there's no verdict, you can't do that analysis. And so the Supreme Court said that this is structural error. If the court finds error, it has to reverse. Because this so infects the structure of the criminal proceeding that, you could think hypothetically about how this harmed the jury, but at the end of the day, the issue remains that there was no jury verdict rendered within the meaning of the Sixth Amendment to be harmed in the first place. And in light of that, this has to be structural error, and structural error means you don't do what we think of as a harm analysis. So, the best way this court can look at it from a Texas precedential standpoint, flowing from Jackson, flowing from Victor, flowing from Sullivan v. Louisiana, flowing from Proenza, is the Dallas Court of Appeals opinion in Twazin v. State, decided 2 years ago. It's a published opinion. And it lays out this very analysis for a similar type of comment. Obviously, in Twazin, the court equated beyond a reasonable doubt with 50% plus 1, the preponderance, what we know of as the preponderance standard. In this case, the court equates it with 60%. Okay, what is the difference between 50% and 60%? For constitutional purposes, not much. We know 60% is greater than a preponderance of the evidence, but I've shown this court in the briefing, there's no support for the idea that 60% even gets you to a concept of clear and convincing evidence. We know, thank goodness for a federal judge in Utah, we know that there's at least one federal court that says 60% is not good enough for clear and convincing evidence. And if something's not good enough for clear and convincing evidence, it's not good enough for beyond a reasonable doubt, because the Court of Criminal Appeals told us in Fuller, clear and convincing evidence is too lenient of a standard for the state in criminal cases. If that's too lenient of a standard, then the judge telling the jury 60% is okay is too lenient of a standard.
What about his gut feeling comment? Is that better or worse than 60%?
I think it's both and neither, Justice Wilson, and that's probably the worst answer I can give you. Let me put it this way.
You may win the prize on that one.
And here's why I say that. There is a substantive difference between general thoughts, when you say gut feeling or even reasonable doubt, and assigning a percentage to the concept. The reason why I didn't raise gut feeling in the issue is because there are the cases that have found no error in a judge saying gut feeling. And I didn't feel that I could make a good faith argument against that given the state of the law. But attaching a percentage...
Other than the First Court of Appeals opinion on gut feeling, have there been other Texas cases?
I believe, Chief Justice Christopher, that there is one of the 14th court cases didn't use the pairing gut feeling, but I think the judge said it's a feeling in your gut, which is basically the same thing. I don't know if it was Latson or one of the other cases, but I think this court has looked at that too. But there were at least 2 gut feeling cases. And of course, the problem with those cases is...
He's out of time.
And I see him over time. Can I continue answering your questions? Please. Most of the cases that have looked at these types of court comments in the past, 1, have not dealt with percentages, and 2, were briefed and framed at the outset under an idea of harm-based fundamental error, which just under Proenza isn't the law. And other than Twazin v. State, I don't know of another case that has framed this issue as a Marin Category 2 due process question. And so what I wanted to focus on with this court is the judge tethering beyond a reasonable doubt to a number as opposed to a concept.
Is there a difference between the judge saying it's 60% and the judge saying a juror might think it's 60%?
In this context, Chief Justice Christopher, no. And the reason why is because the judge is specifically saying in his comment that if, he says, another person's beyond a reasonable doubt is 60%, and he's saying it approvingly. And so he's saying, you think this is 60%? That's okay. And so he is saying 60% is an okay example of beyond a reasonable doubt. And that's where it really is, even framing it that way in that context, he is defining reasonable doubt in that way. When he says it can be 60% or it can be 99%, both of those, the state calls them examples, examples are equations, right? A fruit can be a banana or a pear. That's the same thing as saying that a pear is a fruit. So if beyond a reasonable doubt can be 99% or 60%, 60% is beyond a reasonable doubt. And I'm out of time. I will reserve my time. Thank you.
Thank you.
I think you should have wrapped back around to the 60% confident the bus driver is going to drive safely.
Good afternoon. May it please the court. My name is Nathan
hesitation to
Farmer. I
act.
represent the state of Texas in this appeal. The question at the center of this case is whether a trial court creates error, whether structural, fundamental, or regular error, when it acknowledges the law, that every juror has their own definition for beyond a reasonable doubt that they must arrive at. That answer is no. Chief Justice Christopher, you just mentioned about the difference between a judge saying that beyond a reasonable doubt may be 60% versus the judge saying that a juror may arrive at 60% for their definition of beyond a reasonable doubt. I think that is a much more critical difference, especially considering Tuazin versus State. I know I am probably mispronouncing that, but it's the best that I got. The crucial thing in Tuazin, the fundamental sin that the trial court committed in that case, was equating, affirmatively imposing a 50% plus one standard upon the jury.
Well, didn't he do the same thing here? He said another person's beyond a reasonable doubt, you know, some might say 95, but another might say 60, but they have to prove beyond a reasonable doubt whatever that means to you. Isn't that putting a blessing? Isn't that affirmatively blessing the 60%?
I think it's affirmatively blessing what that juror, as the law requires them, to arrive at their own definition. I think it then becomes...
Well, had he simply left it at that look, the state has to prove it beyond a reasonable doubt, whatever that means to you. Had he left it at that, no problem. But it seems like he affirmatively blessed the 60% view.
I would disagree with the characterization that he affirmatively blessed it. I think that there was an affirmative blessing, but it came from defense counsel endorsing the trial court's decision, the trial court's explanation of beyond a reasonable doubt during their own voir dire. I think that gets us to to determining whether or not error occurred under Proenza. As this court knows from Proenza, we have to determine whether or not a trial court's comments benefited the state or prejudiced the defense. I think specifically addressing the prejudice the defense part, that had defense counsel truly believed that that the trial court's comments and explanation prejudiced the defense in some way, shape, or form, then he could have objected, or he could have not endorsed.
Well, that's true of any structural error. He could have objected.
I completely agree.
Whether it was, terribly prejudicial or not, but there are certain circumstances where the court says you don't have to wait, you don't have to object.
Yes, Your Honor, and given the examples from Tuazin and Trevino, which I put before this court in my supplemental authorities letter, we see the stark differences between the two. Tuazin, absolutely, the trial court made a comment that benefited the state and prejudiced the defense. In Trevino, which deals with a similar Marin Category 2, I know I am most likely mispronouncing Marin as well, a Marin Category 2 for these kinds of explanations of beyond a reasonable doubt. We see those stark differences. This case is more akin to Trevino than it is to Tuazin.
So we keep talking about blessing, but isn't what we should really be looking at is to make sure that jurors understand the level of certainty, the high level of certainty that you need when describing what beyond a reasonable doubt is, if a trial judge should be talking about any of that at all.
Can you please rephrase your question, Your Honor?
So when we talk about blessing in 60%, where I'm asking you, and we're talking about blessing off on it, is 60% as a comment. Do you think that sounds like the level of certainty that the Supreme Court was talking about certainty for jury verdicts in criminal cases?
I think that the Supreme Court was possibly talking about whatever is in that juror's mind. I think it's also up to the parties to elucidate and pull those definitions from the jurors. We saw that in this case during both the state's and the defense's voir dire. Both the state and defense, on their own, elucidated and got those definitions out. So that way, if a 60% juror, if there even was one on the panel, was found and was not put on the jury.
Well, that sounds more like harmless error than not error.
Yes, Your Honor. So I can absolutely try and find some additional authorities to see if there is a harm analysis that you undergo. I would certainly hope that you would undergo a harmlessness analysis in this case, and I think that you would see that 2 words out of the voluminous record in this case.
Well, constitutional error, which is what they're arguing it should be, we have to determine beyond a reasonable doubt that the error did not contribute to the conviction.
Yes, Your Honor.
That's a very high burden. And you have not briefed it.
Correct, Your Honor, I have not. I fully admit that there was a gap in my research with this case. That's why I did not mention Proenza in my brief, and I do apologize for that. However, I do believe that in the supplemental authorities that Trevino is a good guidepost for this court to take. Not only does it deal with Mayor in Category 2, it also addresses similar comments that the trial court made. In both Trevino and in this case, the trial court explained the burden and did not impose that definition upon the jurors. The discussion in this case was not the imposition. That's, to go back to 2000, that was the sin of the trial court. Here we don't have the imposition of that burden, the imposition of that definition upon the trial court. Rather, we have merely a discussion that was then followed up with by counsel for the state and for the defense that led to no error. Plain and simple, I do not believe that error occurred in this case. And that's given that the comments were not...
And so if we disagree with you, that it was more towards the imposition versus the discussion, you agree there is error, harmful error.
Can you please rephrase your question, Your Honor?
If it was more imposition, like Twazin, then it's reversed.
I would agree, yes, that the law has long held that the imposition of the definition upon the jurors is error, and there's no arguing with that, Your Honor. But I do believe that in this case that it's distinct from 2000. That's all I have.
If you would like to do more briefing, we'll give you to January 5th on the harm standard, and we'll give the appellant to January 20th to reply.
And would Your Honor like to discuss the sufficiency point of error as well, or?
It's up to you.
Well, Your Honor, I do believe that the state proved this offense beyond a reasonable doubt. We've discussed in our briefings between counsel and I about Alvarado. I believe that the distinction, or the differences rather, that appellant points out with Alvarado are without much distinction between the 2 cases. In this case, the state proved that only one person was armed, only one person had a reason to kill, and only one person was around when the complainant was shot. That was the defendant. Only one person then later on said, "I only scared him." Only one person then fled the scene, and only one person called his then girlfriend to say it's not you. The jurors are allowed to make the reasonable inferences from the evidence put before them, and they made the only reasonable inference available to them, which was that the defendant shot and killed the complainant.
But the strength of the evidence does not come into play in this constitutional issue, correct?
Right.
If you reach harm, I would say that it does, and that's why I think the state's case was so strong. I think it weighs in favor of harmlessness when comparing the great weight of the evidence to the 2 words in the record, 60%.
And what's your feeling about gut feeling?
My feeling about gut feeling is that
What's your gut feeling?
Exactly what the jurors had to come to that. I think it shows that the trial court was not imposing a definition upon the jury. Because right before the 60%, as Justice Wilson noted, the trial court also gave the high band for beyond a reasonable doubt, that 99% sure. The trial court was merely discussing and explaining the range of possibilities that a juror may have. Going back to what I said earlier, it is then up to the parties to determine where the individual jurors stand. That's a party responsibility. That is what the state and both what state and defense are charged to do during their voir dire. We try and find the best jurors possible, so does the defense. I'm running out of things to talk about, so if there are no further questions.
Thank you.
Thank you, Your Honor.
I have done all the braining I can do today. I has the dumb. He did well. Response?
Does the sufficiency of the evidence weigh in a harm analysis here?
It does, Chief Justice Christopher, if you do a 44-2A harm analysis. If you treat this as structural error, as the Supreme Court said you must in Sullivan versus Louisiana, it does not. And I think I briefed both of those, Chief Justice Christopher, in the opening brief, kind of a belt and suspenders approach, structural error. But if you view this under 44-2A, the state cannot show this was harmless beyond a reasonable doubt, because I have to respectfully disagree with my friend on the other side. The state's evidence in this case was not strong. We may see it differently on whether it was legally sufficient, but this was not a strong case. There was evidence of motive, some evidence of opportunity. I argue no evidence of consciousness of guilt, and nothing more. That is not a strong case.
Being seen running after someone with a gun after having someone steal from you does seems like a sufficient evidence.
It is evidence. It is what I characterized as the speculative evidence of opportunity, because he ran after him with a gun, and no one saw what happened after that. And I will remind the court that what the evidence does show is that between where we see him running and where the complainant was found, there was a fence. And so wherever he ran, the one thing that we know for sure from the evidence in this case is that he never ran to where the complainant was found.
Counsel, what about the statements to the girlfriend?
2 statements to the girlfriend: I scared him, and then the next day say it's not you.
Particularly the second one. That's, I think a reasonable person could hear that and say that they're trying to influence a potential witness's testimony.
I think a reasonable person could definitely speculate to that. Can they infer it to the level of proof beyond a reasonable doubt? I think not in this case, and for this reason. At the point that statement was made, the appellant had just learned that he was a suspect, which weighs against him. But that's all he knew, is that his picture and Melanie's picture were on the TV. And that statement is most naturally inferred as a statement to protect Melanie. You know, don't say it's you. Like, don't get involved in this for your own sake. Because remember, even though the state argued at trial that Eric Aguirre fled the scene, leaving the scene that day was Melanie's idea, not Eric. She testified that it was her idea. And so if she's the one choosing to leave the scene, and now we have evidence of flight for her, are we saying she's a party? And I'm not saying she's a party. There's no evidence that she's a party to anything. And that's why that cuts the other way against that evidence reaching the level of sufficiency. Justice Bridges. To get to your question you asked the state, going back to the burden of proof, is 60% an acceptable level of certainty? No, it's not. There is no context in the world where 60% is an acceptable level of certainty for what we would think of as beyond a reasonable doubt. It's not even a high probability in accounting and finance. Anything that requires accuracy, anything that we care about, 60% does not get us there.
It doesn't get us past
anything in the time of
hesitation
when
to
the
act.
statement was made versus the instructions that came out in the charge later that arguably might change the equation?
No, and I think that actually cuts to the heart of this matter. Just like in Twaza, you have this definition, equating it with 60%, and then the next thing the jury hears from the court is really no other definition. They hear you must find it beyond a reasonable doubt. And the only definition they were given was wrong. And it was wrong in a way that inured to the benefit of the state and lowered the burden of proof. That was exactly what happened in Twazin, and the Dallas court framed it that way in their opinion. They said the only definition the jury got was wrong. So that's error and that's harmful. My time is almost up. If there are no other questions, may I briefly conclude for the court? I was reminded researching in this case that the standard of proof that we use is not an empty semantic exercise. We're not just playing with words. This reflects the value that society places on individual liberty. And we have set that value in a criminal case at proof beyond a reasonable doubt. And we express that by telling jurors that they have to reach a subjective state of near certitude. 60% doesn't get us there. There's a Marin Category 2 due process right not to have that happen. This issue doesn't have to be preserved. It was error, and it was structural error, and it was harmful. So I'd ask this court to reverse the conviction. Thank you.
Well argued. Well argued.
The case of the Bureau versus the state of Texas is submitted, and we are adjourned.
All right. As they adjourn there and go. Mathis, that is actually quite an interesting one. The verdict has been reached, as that was back in September. Let me check my inbox here. Okay, it's slowly downloading. 18 messages. Sony Video Guys. Red Lobster. Greeners. I'll read that one later. I can't find it yet. Check at the top. I'm looking. It's not here. It just hasn't arrived. Did you pay the email stamp? I've got Arkansas State Police. I've got Red Lobster. I've got Video Guys. Did you send it to Top Mark instead? Oh. I've got more Hannah Payne documents. Okay, play that funky music. Got it. Supreme Court in Texas issued a ruling after hearing oral arguments on an issue of whether or not a judge instructing the jury that 60% confidence or 60% surety in their decision is enough to convict. The argument was made that if you were 60% sure the bus driver was going to drive you safely, you wouldn't get on the bus. If you only went 60% of the way, you wouldn't get to your destination. It was a good sign that the justices liked what they heard from the appellant because they let him speak beyond his time limits, and that is rare. Oftentimes, people who argue before a Supreme Court get cut off because they've heard enough. We don't want any more out of you, but them letting him continue and conclude and give his closing was great. Let's see if we can find got the background, a lot of background. How many pages of this? Okay, judicial comment. Did they forfeit? Was the error harmless? All issues that were considered here. Here's the conclusion. The trial court's judgment is reversed, and the case is remanded for a new trial. That is awesome, because this does two things. Obviously, for his client, this gets a new case, a new shot at justice where the end result might not involve him being convicted. That's a win for the client, but it's also a win for everybody under the jurisdiction of this court, as no longer could juries be instructed that 60% is that threshold you need to reach to convict. So, way to go. Texas is a little bit freer today as a result. That is really cool, Mathis. That's just awesome. Thanks for letting us watch that one. That was a good one to end on as well. It's 4:21 actually. It's very important. That 1 minute special. It's 4:20. Mathis, thank you once again. Good find, and I enjoyed watching that. Kudos to the Texas 14th Court of Appeals for streaming that, making it available online, and letting us all learn about the law as a result. All right, it's time to play another kind of music, says Laura. Make it happen. Remember like 110 years ago when we started, Laura? Yeah, we'll play this one. We're still working on getting some court cases for you. We've got another big one coming up here soon. Hang tight, hang tight. You know we always come through, right? Britta, happy birthday. I'm not sure if it's the drugs or the adjustment this morning. I am feeling better. And just by a show of hands, for those of you who have ever been manually adjusted at a chiropractor's office, how many of you have had the body slam move done? Just by a show of hands. How many times? I mean, we're talking about the doctor, chiropractor, positioning you sort of like a pretzel, tied up in a pretzel and twisted, one knee up and everything, laying on your side, and then gets airborne before coming down with the on your side. And just is that a thing? Okay, so I got that one. I got the body slam twice, and it might have done the trick. I'm a new man today. My thumb doesn't hurt nearly as badly. My arm hasn't tingled since the appointment. So yeah, it was good. Not without paying extra. It was a suplex. It was basically like a pile driver, but I was already on the ground. So Hulk smash is extremely helpful. That is good. I've been manually adjusted, just not at a chiropractor's office. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning, right around 8:45, 9 o'clock, right around there. Maybe a little bit earlier if I'm feeling up to it. You guys have a great day. No more members' lives. We're done. And I think I earned a backpack out of that. I can't wait to show it off. You guys are amazing. We'll see you later.